see what you see how to save him from himself here. If I tell this man he just run up to the wicket too fast. The Honorable, the President.
Clearly that break has done everyone a world of good, from what I heard as I entered the chamber.
We will know about to come and fetch you.
No, that's it.
She's okay?
Attorney General, are we reverting to 88Q or shall we continue?
Madam,
I think we're at clause 47.
Madam Chair, may I respectfully ask that we press on? Our team has done a redraft of Q, but I have yet to see it because we've been working through the break. So if we could press on with the 47, which takes us to the schedule.
Clause 47.
Honourable Senators, the question is that clause 47 stand part of the bill. Attorney General, you have circulated an amendment, a proposed amendment.
Yes, ma'am. Should it please you, Madam Chair, we are proposing that the seventh schedule, in the table of the seventh schedule, that we insert after section 43B2 the following new section, and that will be to include two line items. Firstly, 43C1, which is a failure of a driver and any passenger 17 years and over to wear a seat belt while the vehicle is in motion. And secondly, 43C open brackets 1 capital A close brackets, driving a vehicle with a person in the front seat who's not wearing a seatbelt. In cross-checking the parent law versus the schedule item, we recognize that we had inadvertently omitted to include these two items, and so we have proposed that modification.
So, Honourable Senators, let us just deal with the first 6 items of the proposed 7 schedule as right there, and we will deal with the amendments proposed by the Attorney General, which fall under 43B2. They come after 43B2. Members?
Madam Chair, could the Honorable AG indicate to me under section 19(6), the registration of transfer. AG, could you remind me what was the number of days before as it relates to change of possession?
Sure. So 19(1) of the Parent Act, A, you should not use a motor vehicle for more than 7 days after change unless the new owner is registered. B, the registered owner, new owner shall within 7 days after such change make an application asking for the copy. And 19.2. So it's 7 days in terms of the ownership aspects.
Right.
And then it repeats in throughout the clause. Subsection 5. Yes. So that's it. 7 days.
Okay. So there has been no change. You're not proposing any change.
No, sir. What we did, Madam Chair, which may be useful to honorable senators, in the 7th schedule of the bill, we literally took all of the places where we decriminalized and we were going to deal with violations, and we lifted them out of and cross-referenced them into this tabular format which you see in Schedule 7.
Okay.
When we did the second and third pass-through, we spotted that we had omitted the seatbelt and passenger and seatbelt provisions. But so far, we haven't come across anything after several attempts to go through the bill. This is what we've come up with.
Okay. Yeah, okay, ma'am.
Shall I turn the page? All right, and can we deal with 46, 48, 1, 2, 3, 4, 5, up to 62, 46 to 62? Members, any questions on those sections? Then let us move on, 63 to 68. Members, any questions with respect? Okay. 77 to 108, 1A. The last item, fourth schedule. Then we move on to on page 41, the 8th schedule.
Nice.
Senator Ma?
Yeah. Madam Chairman, I observe that the Attorney General has confined the other public bodies to just 4. Is there a company called the National Hospital Management Company Limited? I thought that was under Eric Williams' time. But I can't recall in modern times we had an institution called the National Hospital Management Company. I remember under Eric Williams. We had that.
General?
Madam Chair,
Do we have
I
that?
confess that I am guided by my technocratic team. I imported from chapter 4852
Okay.
in the second schedule, the
Okay.
Airports Authority, the Public Transport Service Corporation, the Chaguanas Development Authority, Chaguaramas, forgive me,
Yes.
and the National Hospital Management Company Limited.
Would you care to advise us? Elucidate or elaborate. Where is this located? And who are the directors of this body? I am not too sure. Could you advise? I'm not too clear in my mind.
My fear in answering that question is that I will express my profound ignorance of any form of answer. But I don't know if it has been changed in terms of the name, in terms of successorship to a modern entity. So quite frankly, Honorable Senator, I don't have the answer to it. But I certainly do believe that I'd like to err for today's day on the side of inclusion rather than the side of exclusion, because I don't know if any successor company has taken this where the name may still be valid.
For clarification, Madam Chair, you see, I think it's an important point because as it is, I am not sure whether an RHA, like the Northwest RHA, which formerly would have come under this particular agency, is in a position to issue these fixed penalty tickets by parking.
So specifically, not an RHA, which in any event is a statutory authority and not a limited liability company. In law, when I do a name change under the company's ordinance previously, or now the Companies Act, Chapter 8801, the fact that I've referred to the old name flows down right down to the new name and any entity which would have taken from it. So that's why I'm erring on the side of caution in the blissful ignorance or unblissful ignorance that I'm in not having any answers to what the National Hospital Management Company Limited is. And if it is struck out and doesn't exist in law, it doesn't hurt us in any event, because then it is not there.
Yeah, well, I don't have my system with me, but I would ask, Madam Chair, if you could put a question mark on this one, so we might have to come back to it, because it doesn't make no sense lawmakers agreeing to an institution that has died, that doesn't exist. So we need to be clear in our minds that what we are doing is proper. So, Madam Chair, I just ask that we flag that, red flag it.
Sure. I've found so far by way of legal notice up to 1987 the reference to the companies. I'm trawling right now to look for it. The two consequences will be if it doesn't exist,
Right.
well then it's okay, because
Right.
it can't in fact gel. But if it has had some form of change where there's a route back to this,
Right.
well then it would certainly help. But I'm looking while we're speaking.
Okay. Right.
Speaking.
Very good.
So we move on to the 9th schedule. And we will deal with the first 3 items. Members,
Madam Chair, if you permit me, I've circulated for honourable members a schedule which is a long table comprising several pages. What we've done there is to list out for honourable members all of the matters which find themselves in the 9th schedule. For members' ease of reference, wherever a member sees under the column remark, wording, that's where we're proposing to change something. So we have gone through a trawl where we have harmonized some of the provisions raised by honourable members. Our demerit point was lower, it was higher. We found that the penalty was not matching with where the current law was. So under the column of remark, honourable members will note that that's where we've adjusted the demerit points to match.
members, items 1, 2, and 3 in the 9th schedule. Any comments?
Yes, Madam President. Item number 3, I know the AG in his schedule has addressed the issue of excess weight, but really, I am not clear on whether there are calibrated scales, whether the Weights and Measures Board in Trinidad and Tobago is operational, so that the scales that would normally be used to determine the excess weight of vehicles are in existence, or whether it is just there as a carryover from the old law.
There are in fact scales, yes, at the licensing authority, number one, where the MGW is in fact ascribed. And secondly, weigh stations are a feature potential along roadways as we build new roadways. The enforcement of the laws of Trinidad and Tobago as it relates to weight will definitely assist us in terms of the damage which secondary roads suffer, where too heavy vehicles which are too heavy for the second-class roads need to be prohibited from being there, and therefore weigh stations are the method that we're actually looking at right now. But to answer your question, there are weigh stations.
In existence now?
Yes, sir.
Okay, very well, thank you.
Madam Chair, before you would go through the schedule, can the Attorney General just clarify for the Senate? Is it that the fixed penalty would be charged and you would receive a demerit point, or is it that you would be demerited and not have to pay a fine?
It may be both. So you may get a demerit point and have a penalty. There's some instances where you'll have a penalty and not a demerit point. There's some places where you'll be subjected to only an offence and no demerit point, because attached to the offence, like breaches for driving recklessly or causing death by dangerous damage, your license is automatically suspended. So we're not going down the demerit route to give you points because you're just out. So there are a mixture of circumstances.
And where both exist, that means both will apply, or it still has the or aspect?
Sorry, would you
Where
repeat?
both applies, like for example, number one, with you have demerit points and you have a fixed penalty, is it that both will apply, or it still has the or it will apply?
Both would apply.
Senator Richards?
Thank you, Madam Chair. Are we at number 4? It's ninth schedule.
No, we,
Oh,
we,
okay, sorry.
I don't think we've turned the pages yet. So, I do,
Madam Chair, if I may ask the Attorney General,
That's what she said.
through you, ma'am, the public service vehicles carrying excess passengers, $750. What was it before?
Madam Chair, may I, just in terms of proposing a structure for your consideration, we have, it took us a little while to do the cross-checking. So in the schedule that I've provided out, there are some amendments which we propose to the ninth schedule, which are reflected in the draft table that everybody has in circulation. Perhaps it may be useful if we looked at the ninth schedule in the bill and specifically took from that each one of the items to indicate where amendments are proposed to match with senators' concerns. I know that this may be a little bit frightening because we get up to page 56 with that and there are 100 items in the schedule, but regrettably it's necessary to approach it that way.
for each item, Attorney General?
Well, there's some of them, for instance, that I could indicate automatically, and it will be in the draft table. So item 1, there's no proposal for amendment, but you see in item 2 that we propose to adjust the demerit points from 4 to 3. So perhaps I could indicate what it is we propose in one round.
All right. Let's deal with items 1, 2, and 3. We will just go. So let's just deal with those 3 items first.
So-
Any amendments proposed?
Yes, ma'am. We propose in the second item appearing in the ninth schedule that we change the demerit points from 4 to 3.
Okay.
And the rationale for that is to decrease it to be commensurate with the fixed penalty of $750 and to maintain consistency between fines elsewhere.
Members? Item 3, Attorney General.
No amendments proposed for item 3.
So, members, we can turn the page to the 9th schedule. And may I suggest item 4?
Item
Madam.
4, there was a concern that was raised. When we looked at the concern that was raised, we cross-checked it and we confirmed that it's a duplication of the existing law and that the maximum fine under the Act was $5,000. So we provided that by way of an explanation. Members had raised the issue of tint, and that the licensing authority, we observed, has the authority to cancel registration where there's a breach of provisions relating to tint, because people were wondering about the severity of the tint provision,
Yeah.
and then we rationalized it back to the severity of the other provision which allowed for cancellation. When we asked the question, we were told that excessive tinting, and I know there's a discretion in that, is a problem for the TTPS, particularly in its control of criminality.
Madam President, Madam Chair, as I would, Honorable Attorney General, I have a concern about this because this has been on the books for a long time, and it's disproportional, as I had indicated in my presentation. In many other jurisdictions, they very clearly tell you that in most, and I took from the bill essentials that we use, the examples of the country. So like in Canada, UK, Australia, they tell you like, the back windows can be darker than the front. And what they do, there's a scientific way of measuring the tint. How we do it in Trinidad, I have been stopped on the road and they're just looking at you and they're deciding. There's a nice device called a vehicle light transmission meter, and they just point it at it and you can determine. My concern with this, though, aside from the application of it, is that there's a vehicle, you put film on a vehicle to get rid of the UV rays. And I understand the issue of criminality, but I think that $2,000 as a fine for that immediate fine is harsh. I think it's harsh. Then the provision that you can lose your registration for a vehicle for having tint is extreme, it's oppressive.
May I just remind honorable senators that I have a requirement to consult with law enforcement and several other agencies, and that I'm not just the architect of this myself. What I've given is the undertaking that we are looking at this and the rationale, the number of offenses, to give a proper explanation to honorable senators and the population as to how this ought to be regulated. We have not yet finished that work. We're estimating that by September we can come back to the Parliament to cause this to be dealt with. It's again done by way of the subsidiary approach. There's the negative resolution position that we've recommended, but I've not yet completed the exercise, and I'm getting a significant pushback from the Trinidad and Tobago Police Service on the matter. So I'd like to make sure I cover the data first and then deal with it by way of a policy prescription.
Well, I will voice that, the Honorable Attorney General, that my view is that this is one of the things that has been
noted, and I share the concern.
And it's oppressive, and it's just tint. I mean, I understand there may be an issue of trying to manage criminality. What they do in the better jurisdictions, they say, listen, the front windows have to be lighter than the back. Every other jurisdiction that has this, you go on the website and they tell you what the level is. You can have darker tint in the back and the windows, but Understood. On the front so they can see.
Understood.
So that all I'm suggesting, there's a way
Senator,
forward.
I understand you clear as day.
So I'm not going to push it any
Because there are
further.
other sectors to be involved, I want to at least finish the exercise with them and then treat with the entire 9 schedule, which is the first schedule of Chapter 4852, and deal with it. Because there's some things that I found that there have been no prosecution for, and that really ought to come off the books of Trinidad and Tobago. But that exercise is not yet completed, and I've already on several occasions indicated that I intend to come back with that by September of this year.
Madam Chair.
Thank you very much, Honor. I'll work with you for the timing on that.
Samuel and then Senator Richard.
Through to the AG, one of the problems I had when we were debating was the lack of stipulation in regards to the grade of tint that is legalized. When you go to tint shops, they have a real problem dealing with what is the regulation, what does the regulation say as to the grade of tint.
I understand.
And until and unless that is stipulated, number 4 does not make sense, because it is left up to the discretion. It's subjective. Here it is.
I'm pleading with you that I agree with you.
Let me finish.
It applies to exactly what Senator Small is saying.
Just let me finish. Daylight, and depending on the conditions of the day, determines a lot of stuff.
I'm sorry, I understand, but it's not going to change my position just yet. I share the same concern, but I'm laying the cards on the table to say I don't have the consultation finished yet, or the scientific data to come and say sensibly, look, 50% grade with this instrument as licensed, but I'm not yet finished it yet. So I'm proposing that we treat with the ones that can be treated. The demerit points were observed, the incongruities in the legislation. But I just don't have the data in front of me yet to get to where common sense says we should. And I agree with you. What's the alternative? Make it up on the spot now and then get a pushback in a different quarter?
No, I'm not saying that. I'm talking about the attitude of people on the road, the attitude of officers on the street, the attitude of licensed officers.
I've seen them having young men pull down the tint on the side of the road
and treat them, and which is not right. You understand? As a matter of fact, I pulled law for somebody who told me my tint was too dark, and that's how the vehicle came.
Agreed.
And I said to him, show me the law. Show me the law. And he says, all you feel all year is it because you're minister.
AG, I think tints come in various grades and they come in various specifications. And I think it would be important in your consultations to determine with the licensing office what is the specification. It would have a UV code on it. What is the specification that is acceptable and what is not acceptable, and we will put that in so that to cover Senator Samuels's point, everyone will know when we are tinting our vehicles what is the accepted grade and what is the not.
Just to tell senators,
Yeah.
the Trinidad and Tobago Police has been considering this issue for 2 months. They have a policy document from us, and they are going to finish the exercise. I join everybody in this room with the need to regulate this thing with certainty. It's what we call a sore foot matter. It hurts your foot when you step on it. I accept that. But the process that I've taken is to give them the position, get their consultation, get the evidence from the courts and the licensing authority to say, this is out, this is in, this is to be changed, and here's why.
Senator Richards.
Thank you, Madam Chair. Through you, Attorney General, Honorable Attorney General. Just in terms of a suggestion when you are having these consultations, part of, to me, the challenge is with the wording in terms of with glass so tinted, treated, or darkened that it obscures the view. It doesn't really specify the intention. Is it to identify facial features?
Sure.
Especially in the context of the new CCTV cameras that will now have to also capture images. And also there's a new phenomenon of transition film, which may be quite visible during the day.
True.
Or at low light levels and increase in obscurity during high light levels. So all these need to be taken into consideration. And I think more specificity regarding obscuring the view in terms of recognizing facial features, because that's what law enforcement is interested in terms of thwarting criminality.
Understood, and excellent suggestion.
The problem I have with all of this...
Senator Crease, just 1 second. I had indicated to Senator Mark he would speak after Senator Richards, and then we will take your observations. Senator Mark?
Yes, thank you very much, Madam Chair. Madam Chair, I'd like to ask the Attorney General if we could have summoned the Commissioner of Police here. I would have requested that, so we could have gotten data on this matter. It does not make any sense having something in legislation that is subjective, that is discretionary, that can be used whimsically, capriciously, in a very punitive way by law enforcement. Is either we delete that completely or we put a sunset clause so that, as the AG is saying, he's expected back here in September based on reports that he's supposed to receive. Is either we have a sunset clause for this provision or we remove it completely from the legislation.
Madam Chair, thank you. If I could just indicate, I have in my hand here, for instance, for the month of January 2015, that there were 14 matters for use vehicle glass tinted treated to obscure view. So I've been working on the data. I'm taking a very scientific approach to it. I hear honorable senators, but you really want me to come with something that is not subjective and which is data driven. So they are 2 months into the exercise now, and we're going to finish it. It's not been treated with for many, many years. We have an opportunity now to treat with it, and an executive which is willing to do it. And I've given the House, the Senate, an undertaking on the floor of the Parliament that I'm going to deal with it. And we have a committee of undertakings. I don't know how much else to convince honorable senators that I'm serious about doing it.
Senator Crease.
We are not doubting your sincerity or dedication to the matter. What we are concerned about is our unscientific provision. And the whole adage is that better 10 men go free than one hang. It has to be the duty of legislators to get it right or leave it alone. And that is the point we are making. Until we can get it right, our duty as legislators is to leave it alone.
Well, we
That's
are
the
leaving-
bottom line.
Yeah, we are leaving it as it is, but.
No, it is
yeah.
wrong as it stands.
Okay, may I
Because
ask-
it is subjective.
Sure, may I ask?
And that is why we need to remove it.
Sure, may I ask for a suggestion on how to do it?
The bottom line is to remove it until you can come with specifications saying this is what is permissible.
That's not good enough.
Anything else is wrong. If you have not arrived at that point, then we need to strike it down as bad law.
I respectfully can't agree with you, Senator Crease. I've already given on many occasions, including in the last 5 minutes, a rational approach to dealing with this matter, and I respectfully can't come up with anything better just now.
Okay, could I come in here, AG? Through you, Madam President. Under 20, you have no demerit points for failing to comply with a traffic light. I'm just wondering whether, given the uncertainties involved, you are prepared to keep the fine.
Sorry, which item would this be?
Item number 4.
Item number four.
Whether you are prepared to keep the fine but remove the 3 demerit points associated with this infraction. Okay. Okay. Yeah, I'm simply saying, since in this schedule you do have offences which are devoid of demerit points, I am saying that given the uncertainty involved and the fact that at some time you indicated to us that the minister via order can change this, that at 3 demerit points seem to be a significant penalty for a matter which may not be the fault of the driver. It's significant because if you have 10 demerit points, you are going to lose. So I'm just simply wondering whether, in the interest of equity, that we can say, yes, let us keep the fine, but strike off the 3 demerit points for the time being, and when we can verify with scientific data what the UV position is, we can then determine the amount of demerit points on it.
That's to pull at the tapestry of the very thing which we say we want to analyze. And what I'm asking honourable senators to respect is that I'm not the sole architect of this. It isn't Faris Al-Rawi, the person standing here, who makes a decision. There is a collective of law enforcement, licensing authority, etc., that has to be approached in this regard, and it must be in a disciplined approach.
Okay, Attorney General, remove the fine and keep the demerit points.
We're trading horses, Senator, on something that I have no data on.
Let me add my little voice to this.
Senator Ramkisoon.
Thank you, Madam Chair.
Yeah.
Through you. In 23, 1D, which is what we're looking to amend, it has a fine in the Parent Act, which is liable to a fine of $5,000, right? We're saying a fixed fine of $2,000. We understand your
Dilemma.
position tonight, this evening, and we want to say I support removing the demerit points because you have a hefty fine if you go to court of $5,000 and you have a fixed fine. I would say remove the demerit points because we didn't get it right. And what is the harm? What is
Agreed.
the harm of removing the demerit?
I'm trading the horse in an unscientific way, but I cannot have, it isn't a one will prevails. I'm prepared to do that. Your point makes sense.
All right, so honourable senators, can we move on, please? We will deal with item 5. I think that remains the same, Attorney General.
Yes, ma'am. Yes, please.
Item 6.
Item 6, AG, did you make a change to item 6?
No, sir. I
Okay.
hadn't proposed one.
Right, because in item 6, I'm not clear. I know it's a serious charge, 14 demerit points, but in the text of the bill itself, there was a fine also of $10,000. Why is the fine not also here? Could you explain that to me? Why the fine is not here as well, of $10,000?
Because we weren't treating with it as a fixed penalty offence. So we were dealing with it as a prosecution offence.
All right.
So for this one, it's not decriminalized, it's not fixed penalty. You're going to court, and we're giving you demerit points if you're proven guilty in court.
Okay,
and
fine.
we've gone for the very high version, and we do propose an amendment based on the substructure of what Senator Choate gave to us in respect of 88Q.
All right, excellent, thank you.
Item
Madam Chair.
7.
Sorry, Madam Chair. Just for clarification on this particular point, just that I understand you clearly, driving while disqualified, you're giving 14 points, and if you go to court and you find guilty. But the 14 points take you to the stage of losing your license for
Yes,
1
ma'am.
year. Okay, so we're saying that once you're charged, you will lose your license for 1 year.
Yes,
This is
ma'am.
what is, okay, thank you.
Because you have to not once you're charged, once you're convicted under the new version as we'll propose to redraft in clause 35.
Item,
Okay, again, clarification, AG. You see, we are imposing 14 demerit points, but an individual is already disqualified from holding a driver's license, and he has been charged with that particular offense. What is the use of another 14 demerit points? Could you elaborate?
Understood, because one may apply for a pardon and obtain it, but your demerit points may still exist, yet to be expunged until we come down to 2 years after you've clocked over.
item 7,
Madam President, Madam Chair, I'm not sure in the notes that the AG provided us with, these fines are correct because it's not consistent with the Parent Act or what we have passed.
It's just meant to be explanatory of the differences between the different approaches. This is like an aid memoir to make some sense of the correlation between 4852 and 4850 and our demerits. So I've just tried to make the task a little bit easier.
item 7, Attorney General, there is a change.
Yes, ma'am. We propose to adjust from $450 to $1,000 and to adjust from 2 demerit points to 4. Honorable senators had indicated the severity of the treating with the helmet, and what we did, we saw that, and we also saw a lack of harmony with items 8, 9, 10, and 11, and we sought to harmonize those.
If I may ask you publicly, what is the difference between a police officer riding without a helmet and a police officer driving without a seatbelt?
Perhaps the same as the policeman driving with the telephone in his hand as well.
Well, I remember some people say that people are legally authorized or permitted not to, police officers. So if they're permitted not to drive with seatbelts, then the officers who ride are legally authorized not to ride with helmets. So I think it's something you need to look at.
Well, I'll ask the Commissioner of Police to look at that, sir, because I can't. I can, but I could only go so far.
So we move on to items 8 and 9. Attorney General,
We propose no amendments, Madam Chair, until we actually get up to item 12.
so items 10 and 11. Item 12,
Madam Chair, we proposed an adjustment of the demerit points down from 12 to 9. This deals with the instruction of a learner without a valid driving permit, etc. And we looked at the description of traffic violation and sought to amend it to make it clear what the breaches entail. We also looked at section 15 of the bill, which seeks to amend 46 of the Act to increase the fine from $1,000 to $5,000, and we therefore sought to attenuate the number of points in line with the logic standing behind all of those matters.
item 13. Any changes?
No, ma'am. The next one for us,
Item
subject to other
14.
members, is 14. Madam Chair, we had proposed, again in recognition of observations, that we reduce the sum down from $3,000 to $1,000, and that we do a concurrent drop down from 14 demerit points to 6 demerit points. The fixed penalty fine and demerit points were adjusted to be consistent with the upper limit of the excessive speed limit in item 13, that is in excess of 31 kilometers, And we also had a look at Section 21 of the bill, which sought to amend Section 63 of the Act to increase the fine from 2,000 to 6,000. So we spotted the lack of harmony between the two, and we made the adjustments downward from 3,000 to 1,000 and from 14 points to 6 points.
Honorable Attorney General, I have some concern with your interpretation of this activity.
Sure.
I think this is one of the most hazardous and risky of all activities that road users engage in. It is many times more dangerous to people who are engaged in it and people who are bystanders. It is 2 or 3 cars on a highway racing from one point to the next. It's called drag racing. And I would have thought that given the kinds of accidents we have known in the past to have resulted from this activity, you would have raised the fine to $10,000. This is serious. This is not, these are young people who think that they know what they're doing and they're not. Raise the fine to $10,000 and keep the demerit points as it is, disqualified.
Senator, we looked at your observations, which we share, and we found comfort in Section 71A of the Act and 72 of the Act. 71A deals with dangerous driving and 72 deals with careless driving, both of which are an automatic knockout punch. Prosecutor, for which there's prosecution by offense and there's imprisonment because we've not decriminalized those aspects. Those are available to treat with this matter in particular, and we think that that's how we can address it on this point.
What concerns me is that it appears as though this particular activity is then open to some kind of interpretation where the penalties will range from severe penalties for dangerous driving to really penalties that are not so severe, and there is no clarity in my mind as to what the penalty is for this dangerous activity.
Here's why we've taken the graduated approach. What if 2 people start off, 2 young boys side by side, and they step on the gas for 2 seconds, side by side, somebody spots them. They didn't take an actual fast and furious approach towards the drag racing, careless or negligent driving, or dangerous driving. But a policeman looks at these 2 and says, right, automatic knockout punch, 14 points, you're gone, etc. Because there was so much room for subjectivity in that approach, we left the offenses in 71A and in 70, aside from that, in 71A and 72.
I just wanted to make a point on 13.
Well, aren't we on 13 now?
That's it. We're past that.
We're on 14. Is it
I was going to allow you. I thought we won 13. Okay, we will go back to it. But at this stage, I really want to encourage senators to keep up with the flow, okay? Because we're moving up. We've been here a little while now. So let us just revisit 13. Senator Shrikesoon.
Through you, Madam Chair, to the Honorable AG. The first tier of 1 to 9 kilometers per hour. We have to, this is my suggestion here, is that most of our cars are equipped with speedometers that can't give you an accurate reading of 1 kilometer. And to really charge someone $1,000 for 81, I'm sure if they're doing 81, the intent is to obey the law. So I want to ask that we give a tolerance of maybe 3, and up to 3, just assign a demerit point, but no fine. 5, okay, 5. Of a demerit point, but no fine, because they clearly at 81, 82, there is the intent, and they can't accurately do it. Probably these speed guns could give you exact, but on our cars, it doesn't permit us to know what, and it could just happen in a second or 2. Yeah.
Would you mind translating that proposed amendment to 13?
One by 1 to 5 kilometers per hour. No fine. No
so
fine.
not 1 to 9, 1 to 5.
Yeah, 1
so
to
change 9 to 5.
Right.
Right?
Sorry? Yeah, changes the 1,000 to 0.
You can't because you're over the speed limit.
But, oh my goodness.
The speed limit is the speed limit. You can actually, you have to obey the speed limit.
Yeah, but I'm saying in terms of regulating your driving behavior going down the road, 81, I mean, it's not.
I should tell you that we will shortly be coming to the country to raise the speed limit. It's before the cabinet right now.
Even if it is so, like, if, let's just say it's 100, at 101, a driver really doesn't have.
Senator
So-
Shriki, we have to draw a line somewhere.
Yeah, I understand, so I'm still saying.
If it's 101 and you're not sure about your car, drive at 95.
No, but many,
Doesn't mean to say you have to drive.
no, but there's a tolerance,
Yeah,
tolerance.
We move on then. We've 13, 14, we're on to
All legislation gives a tolerance.
yeah, we don't need USCS.
We propose an amendment to 15.
item 15.
Madam Chair, we propose a reduction in the demerit points from 6 to 3. And this is to give us consistency with 16, 18, 19, and 21. The maximum fine for this section is subject to Section 91 of the Act. And Section 22 of the bill seeks to amend 63(8)B of the Act to place a fine of $4,000. So we recognize that the demerit point was outside of the link, the chain, and that it should be dropped.
This is for 15.
Senator Shriki?
No.
So if we could move to item 16.
Madam Chair, we propose again for harmonization of clause 15, 18, 19, 21 with 16 that we reduce the demerit point from 4 down to 3.
Honorable Attorney General, this is the only fine, I could be mistaken, of $300 that I have seen in the schedule. Maybe it's not the most popular fine, but really, $300 and 3 demerit points. Do not seem-
We've amended it,
You've amended it, okay.
Senator. I don't think it's $300, it's $3,000.
It's 3,000, okay, very well.
An order made under this section may prescribe in respect of a convention thereof a penalty not exceeding $3,000 and imprisonment for 3 months.
Okay, what is the fixed fine for breaching a
So the
traffic order?
fixed penalty is 1,000.
1,000 now, very
Right, so
well.
the fixed penalty.
Okay.
Which is different from the other aspects.
All right.
Yeah?
Items 17, 18, 19, 20, and 21. Senator Raful.
Thanks. Can I suggest that number 17, the demerit point, be reduced from 6 to 3?
You need to state
Give a
why.
rationale.
Yeah?
When I made my contribution last week, I referred to the fact that a police officer has quite a bit of subjectivity in his jurisdiction to give 6 demerit points for this offence, as well as to give demerit points for other offences within his remit. So within one interaction, a police officer can give someone 6 demerit points for
No.
not being compliant with the
yes.
instructions, as well as 3 points or
No.
6 points or
You-
5 points.
You can
or
only
4
get
points for
one
something else.
demerit point, the highest of all of them. So if you get stopped on one occasion and you
Okay.
commit 4 infractions and then 4 demerit points, you get one only, which is the highest of the number.
Okay.
The rationale for 6 was to cause compliance with the word of a police officer, which is a serious matter. And today, if we take note of the videos which circulate in our country, where people are literally knocking down policemen or brazenly approaching their authority, I think that this is a serious matter. I've just heard Senator Samuel say something which is an equally important point, which is that police officers are knocking down civilians. I can tell you that you're going to see an amendment to the Police Complaints Authority in September, which will deal with some of these matters.
Madam Chair, through you. Thank you. This particular point on number 17, I think should be reduced to 3, as Senator Raful has said, because for a new driver who's very much afraid of law enforcement, you're putting them on the verge of losing their license for 1 year, especially if it's at night. Well, I know at night I'm not stopping for police officer. So, Madam Chair, I would like that to be considered for 3.
Madam Chair.
Senator Samuel.
I have a little problem, make it explain to me, Honorable AG. 17 talks about failing to comply with the directive of a police officer, constable. 66 talks about the same thing. The fine legal situation here is 2,000. I don't know if we amended that. And the possible imprisonment of 12 months. How do we balance it?
Well, they are mutually exclusive. The fixed penalty amount is 1,000, so the officer can choose to give you a fixed penalty offense. But if the officer chooses to take it a step further, the officer has that available
The
to him.
traffic warden could give you 10,000.
The failure to obey the traffic warden, yeah, up to 10,000.
Well, so in the same situation, the traffic warden stops you, and it's 10,000. The police officer stops you. You fail to, he gets a hold of you, it's 1,000 if he chooses to. Kind of.
The range of opportunity available for the police officer who you refuse to obey also includes the power of arrest. So he has a greater balance of powers, I should say, a greater arsenal of weapons in his bank.
Penalize on the person. I mean, I'm not too sure if laws are based upon who you offend. So because you can say that if a police constable charge you is different if a senior superintendent charge you. And I don't think laws are made based upon who you offend, but what is done.
Well, in this case where we've got a creature who is the traffic warden, who is not being obeyed, and who has been reduced to a toothless entity, we've got to also contemplate the who you offend position, bearing in mind the arsenal available to them.
Is that law? Is that correct law?
Senator Richard.
Thank you, Madam Chair. Honorable Attorney General, I want to endorse the suggestions for the reduction in terms of 17 to 3 for the simple reason that I think it's quite onerous, and I have been victim very often, and I'm not in any way trying to diminish the authority figure of police officers, of getting confusing instructions from police officers, which can in some instances be deemed a flagrant disregard to comply with the instructions. And I think getting a 3 demerit point sends a strong enough message that you want that in compliance, as opposed to 6, which takes you so close in one instance to possibly losing your license.
Senators, all through you, Madam Chair, have raised a very important point. The balancing act is between causing compliance and those who may be potentially exposed to some form of exploitation. I don't mean to be pejorative of people, but let's deal with that. Could honorable senators live, I hate to be a horse trader, but could we live with 4? Senator Amin?
Senator Mark.
Yeah, Madam, I'd like the Attorney General to probably consider. I hear you that we want to maintain law and order. We do not want anyone to be taking advantage of anything in the country. Now, at the same time, how do we deal with police officers whose integrity and honesty have come under scrutiny? It's a balancing act. Madam Chair, I was intending to lean on a 0 merit point system and just have a fine. Because sometimes, Madam...
No, but the point, you've made your point, Senator Mark.
Yeah, so, but I don't support the 6 merit points. I think AG maybe, as I say, we're not horse trading, but maybe 2, maybe
Senator,
3.
Attorney General.
Sure. Madam Chair, as I sit and I think about what honorable senators are suggesting, I'm awakened to the fact that there's an alternate remedy available to this policeman. This policeman under Section 66 could charge you and then take you the long haul route. And therefore, insofar as the officer has the ability to charge you or give you a fixed penalty for 1,000, it may be in keeping with the suggestions for 3. Because he can elect which route he wishes to go. He can double it up by the offense route or take it down. So, Madam Chair, perhaps we should agree with the 3 as the marker into clause 17. Does that meet with the Senate's
Section
approval?
18?
Yes, Madam Chair?
Yeah, section 18. Item 18. Item 19. Item 20. Item 21.
Madam Chair, we proposed that the fixed penalty be increased from $750 to $1,000. And here I found rationale in my own recommendation for 3 in the previous clause, because it would at least match up with the 1,000 versus 3. The rationale for this is to make it consistent with breaches for orders and traffic signs under the Act in general. When we went through, we double-checked where all of the other offences lay now violations, and so we sought to harmonize it that way.
Madam Chair, not that I want more offences, but I saw in 19 and 20, it has been amended. Am I wrong? Or is it amended or is not amended?
Not amended.
Okay, great. So, all right. The table doesn't stand then. Thank you.
21. We just dealt with that. Right?
So changing 750 to 1,000.
22.
Madam Chair, we propose to delete this entirely based upon the observations of the Honorable Senate.
23.
Madam Chair, we propose again to cause the harmony with the other sections to bring this from 750 to 1,000 and to maintain the demerit point at 3.
24.
No amendments proposed.
24, though,
Yes, sir.
when it's driving under the influence of drug, we had, in fact, visited this when we said that drugs were going to be eliminated. Didn't we say that?
Well, what we did was we eliminated drink, not drug. So we left drink in the section which follows.
Yes.
Section 70, that's section 70A.
Right.
We left drug alone. We didn't include a fixed penalty for that because it was something which you were going to be charged for and taken down the line. And if convicted, you would then, because it's a serious matter, suffer a heavy blow, which is 9 points.
Aha. Okay.
25.
And 25 is where we had drink, and again, no fixed penalty because you're going to be prosecuted for that, and if convicted at 9.
Didn't we say when we were going through the clause 28 that drug, which there was a definition for the purposes of this section, that was, if you go to clause 28, subsection 5.
Intoxicant.
We indicated that for the purposes of this section, drug includes any intoxicant
We deleted
other than
that.
alcohol. And we were going to delete it.
We did.
Now, if we deleted it, whither then 24?
Whither then 24?
Yeah.
We're deleting drink from that clause. We're keeping drug.
We're
We
keeping
didn't
drug?
seek, yeah, we kept drug. We didn't define drug as
Right.
any intoxicant
Yeah.
because of Senator Choate's observation that it could be vague,
Right.
and therefore we deleted the definition of drug.
Yeah.
Okay, but we only included drink.
No, sir, we removed drink from that clause.
Okay.
Yeah.
We left drink where it appears in
Yes.
70A.
Yes.
So they're two standalone offenses.
Right.
If you're under the influence of a drug in 70, and if you're under the influence of drink in 70A.
Right. Okay. Final clarification, is it or is it not that we are deleting in clause 28, 5, 28.5? Are we deleting all of 5? If we could revisit clause 28. Are we deleting subclause 5?
No.
28.5?
Just a second.
Yeah.
Yes.
We've dealt with clause 28 already.
Yes, and I want to see how it meshes with what's in the schedule
Yes,
here.
we are deleting it.
You are deleting it?
Yes, sir.
All right, it is deleted, but, and you are satisfied, therefore, that 24 still holds, although we deleted 5?
Yes, sir.
Very well. Yeah, exactly.
For driving under the influence of a drug. Let me just say, right now, we're looking at something called a drugalizer. It's a bit of technology which exists in the United Kingdom, where you can actually test for drugs in the system as opposed to alcohol with a drug. which will take us out of the obscurity of you were observed and somebody's circumstantial evidence to be corroborated. But the fact is that drugs do exist, whether prescription or non-prescription medication or otherwise. So we're looking at the concept of a drugalizer, and we intend to knock on the door of the Parliament shortly.
Senator Choate.
Madam Chairman, thank you. Honorable AG, may I respectfully suggest that we use the word dangerous when we talk about drugs, because otherwise prescription medicine would fall into the category where you could be fined and so
you're
on.
right.
And presumably you are allowed to drive while using prescription medicine responsibly.
Senator, you're absolutely right. My fear with accepting the recommendation for dangerous drugs is that dangerous drugs is something which is defined under the Dangerous Drugs Act. There is an equal danger in the abuse of prescription medication to such an extent that you're intoxicated. And the recommendation and rationale, because when I asked why we would deduct from that clause, the explanation given to me from the several stakeholders was that, okay, drink is dealt with in 70A, but there is still a phenomenon for drugs, and there are positions where people are intoxicated by the use of prescription medication as well. They should know better. So putting it in the category of just dangerous drugs means that that cohort of people that abuse prescription medication, which is not a dangerous drug, would be potential liability on the road.
Yes, I wanted to ask the Attorney General could clarify. You indicated that the government is looking at drugalizers or instruments to test drugs. In the meanwhile, how would the arresting officer determine whether a person is under the influence of any drugs?
The same way they used to do it under the influence of alcohol prior to the breathalyzer, which is the various tests and techniques for observation as to whether one is intoxicated or not.
While I agree that we should have a method to test the level of drugs in a person's system, I feel we secure the interest of justice better when we have a scientific method of proving the quantum in the person's blood. So while I'm willing to support the drugs being here, when we have a drugalizer to present an objective piece of evidence to the court, I have reservations in supporting it now, because there is no way for the arresting officer to prove to the court through some measurable objective method the level of drugs in the blood as it is now with alcohol, and we have made that advancement with the breathalyzer. So,
yes, ma'am. Well, I accept the observations of Senator Amin. It's certainly something that we're looking at. The sobriety test, whether it is by way of sobriety for intoxicant, which is a drug, or sobriety for testing, which is an intoxicant, which is alcohol, can be done by way of blood testing or other techniques, and also the use of novel technology like breathalyzers. In fact, it was Arrive Alive that pointed us to the drugalizer in the United Kingdom. I thank again Sharon Inglefield for being constantly vigilant on all of these matters, and we're looking at that so that we can have the scientific approach applied to treating with this issue. It's not the most satisfactory approach.
my suggestion is that we remove it until we introduce the technology, and then you will bring that in the use of the technology, as was done with the breathalyzer.
Madam Chair, I'm cautious not to touch it now, because especially amongst the younger generation, the use of prescription medication, glue, other things is a real phenomenon, and we've got to be careful about that. Cannabis is a real phenomenon.
The drug abuse is a problem on its own. Proving to the court in an objective manner, using a scientific method, is the issue that is under consideration here. What is the objective scientific method that you are going to present to the court as your way of measuring the level of drugs in the
standard methodology, which is currently in practice, which is to be determined by a court of law on an objective standard basis. Walk the white line, observation, pupils rolling over.
And again, I'm saying that
items found.
previous to having the breathalyzer, the police officers use that. We have advanced.
And they still do, as a
thankfully.
matter of fact.
All right, but the evidence, that the scientific evidence that is used, and again, we spoke in other instances of the subjectivity, where we have so many police officers who victimize people and so on. What in one police officer, under his honest discretion,
Sure.
may be that a person is under the influence of something. It could be that they got disturbing news this morning and they're just a bit phased out.
Which is why, Madam
But
Chair.
he has no method to prove to the court.
I think the Attorney General, I think your point has been made.
Yeah, so I would answer very succinctly as follows. This is why we are not prescribing a fixed penalty for this. You get only the treatment that the court says you will get after a trial in court for an offense under Section 70 or Section 70A. If you are convicted, then and only then does the penalty of law visit upon you, together with the demerit points.
Senator Samuel. Okay, so the same question as Senator Amin. Okay, Senator Richards.
Thank you, Madam Chair. Honorable Attorney General, you reference people abusing prescription drugs. There are some people who don't intentionally overdose or abuse prescription drugs that are affected negatively while operating a vehicle.
Pineapple.
That's one. They can be found liable in this instance. And also, the issue of 9 demerit points in that case, you used the dictum earlier of erring on the side of caution. And while I understand the need to discourage strongly the abuse of drugs and driving a vehicle because of the danger it poses, not only to the driver but to others, I think it's unfair to people who may end up on the wrong side of the law with this. We have laws against cannabis use. We have laws alcohol in terms of officers using a test before you can smell alcohol. You can't smell a prescription drug or cough syrup that may dissipate in your body and not be able to be proved for one's defense in a court of law. And I think this 9 demerit points added to this, when we have no definition of a drug and or drug-ELISA test to ascertain veracity of the charge, is quite not in the interest of justice.
Sure. Madam Chair, may I respond? The clause section 70, which is in item 24, is referenced to the law, section 70 of the Act, which says any person who, when driving or attempting to drive or when in charge of a motor vehicle, is under the influence of a drug, as we amend, to such an extent to be incapable of having proper control. That charge must be given to you. You go to court, and then you're defending yourself with a range of defenses. It wasn't that I was to such an extent, the observations were unscientific, it's just not true, or it happened and I wasn't aware, could you please reprimand and discharge me or treat me otherwise? There is a judicial process involved in determining guilt, and we've not treated with this with fixed penalty, which is just automatically look your penalty, pay it or contest it. So because there's a judicial process and because it's only when there's a finding resulting in a conviction that you actually suffer these penalties. So respectfully, the safeguard is in the judicial process, where you can volunteer your defense and prosecute your defense.
In the instance, because it is such a obvious contentious issue, isn't it in everyone's or in the public's interest to err on the side of caution? And we're not suggesting throwing it out, but just as you say, you'll come back in September, we can revisit this at some other time.
What do you suggest, Honourable Senator?
That it be struck out.
I couldn't agree to strike it out because the statistics that we have here include so far, and they're not yet complete, but at least for 2015, I have them month by month. It includes charges along these lines. So it's a real phenomenon coming out of the magistracy of Trinidad and Tobago.
And could you just give us a sense of the evidence that would have been proffered in those cases?
I couldn't tell you the evidence because I didn't go into evidence, but what I checked was what were the charges for each one of the items. Is there a charge for advertising on the side of your window taxi? Is there a charge for failing to comply with the police? Is there a charge for no helmet, overcrowded vehicle? I went through all of the matters
With specific reference
to get the data.
with respect to the influence of drug.
Sorry, for this particular month that I have, I don't have that particular point, but I certainly will get it. Senator, your suggestion that I've got is delete it entirely. I'm not in a position to agree to that without the data just yet. It's a feature of the existing law as it is, contained in Chapter 4852 as it is. So I haven't sought to treat with it in any other fashion than the existing law.
Shouldn't the data also drive inclusion?
Pardon? Should the data
Shouldn't the
also
data
include?
also drive the inclusion of it?
I'm sorry, should the data also?
You said deleting it. There's no data to support deleting it. Should delete
No, I have
it?
no data at all. I couldn't. Well, first thing is that 1 month's data in one of the courts isn't sufficient. The fact is that it does exist. It is a position. The mischief observed was that there was a confusion between having drink in that clause and drink in the clause just after, or the section and the section just after. We were asked to clean that up. The suggestion that we delete it entirely is to avoid a real problem on the roads of Trinidad and Tobago, which is that people may be driving under the influence of a drug.
All right, so
Attorney General, I don't think anyone is countering you.
Senator Richard, I think that enough has been said about this matter. The Attorney General has been made aware of the sentiment. Senator Rafoon.
Through you, Madam Chair. Honorable AG, perhaps I can suggest a compromise. I do recognize that there's two different issues here, one with the breathalyzer and one with drug. Breathalyzer is objective. I agree with that staying at 9 demerit points. The drug one is still quite subjective. I would suggest that one be reduced to 6, not struck off altogether, but there's still an element of subjectivity in it that I find quite dangerous for drivers. And I think that 6 is still a large disincentive for persons driving.
May I ask you to think about it this way? Isn't the mere fact that it's more subjective, therefore, doesn't that make it more likely to be not accepted by a court? Because you can't battle the breathalyzer. That's the microns. You either refuse to give it or not. That's your blood analysis. But you have a better fighting chance to say, well, this thing is entirely subjective. I couldn't walk the line because I have polio, or I am a diabetic, or any one of the other defenses that apply to you. So you have a greater chance of acquittal in the more subjective route than in the more scientific approach. So it's harder to prove.
Honorable Attorney General, sorry, I beg your pardon. Madam Chairman, I just wanted to make two last points on this issue. One is that when police officers did not have the scientific method of testing for alcohol, generally speaking, they had stopped charging for drunk driving because they knew that the cases would be thrown out very easily. The second point is, if you are saying that the likelihood is that these cases where persons are suspected of driving under the influence of drugs are likely to be thrown out, then it means that we are clogging up our court system with cases which shouldn't be there. And I think that is a very serious consideration for us to take into account. Because we may be clogging the system with persons who fail the test because they suffer from Asperger's disease, they may be high-performing autistic people. There are any number of categories that you can talk about which would result in a criminal charge which is likely to be thrown out at the end of the day. So it seems to me that it's pointless.
Senator, you may very well have hit all the right chords, but I just don't know because the consultation is not finished on that in terms of the revision. But what I did find great strength in was the recommendation by Arrive Alive to have a look at the drugalizer and where it is to make sense of this particular law, which is on the books of Trinidad and Tobago. I'm just reluctant to throw it out just now. But we are looking at it actively.
Madam Chair, it seems that the AG will have to revisit this particular provision in light of the deep and grave concerns that we have expressed on this side, and I would ask him to respectfully consider withdrawing that entire provision.
To summarize the position, hating to be the one to say that I understand and accept but beg to differ, I respectfully can't accept that submission, but we are actively looking at the position to improve the law to move towards an objective standard by the introduction of a drugalizer technology.
Madam
No,
President.
I think,
Madam
Senator
Chairman.
Amin, enough has been said about it. I think
I thought this is what the committee state was for.
yes, Senator Amin, and please.
But we're now
Please.
discussing policy.
So we are now going to move on. The Attorney General has
I have a
heard,
suggestion to make.
the Attorney General has heard the comments, and we are now going to move on. There has been enough discussion on this particular item. Item 25. Item 25.
Madam Chair, we had proposed to treat with the drink driving exactly as it is currently in the law. So we have no amendments to that.
Item 26.
Madam Chair, we had no amendments to that either.
Item 27.
Nor any here.
Item 28.
Yes, I have 28 as well.
Senator Mahabir.
Okay. Honorable AG, item 28 refers to careless driving, and we did discuss careless driving prior. You indicated it is a person who drives a vehicle on a road without due care and attention or without reasonable consideration for other persons using the road. It appears to me to be a very serious charge because you are injuring not yourself only, but potentially pedestrians and other users of the road. Yet when I compare for consistency what you have levied under item number 9, driving a vehicle with a person in the front seat who is not wearing a seatbelt, the same fine of $1,000. So the same fine of $1,000 and the same fine of $1,000 for careless driving. I would have thought that with careless driving you would have imposed a heavier fine, something in the order of 5 times the amount. And unless I'm mistaken, you have 4 demerit points for driving with a vehicle with a person in the front seat who is not wearing a seatbelt, which is a serious offense. But for careless driving, you just have 6 demerit points, and I'm looking again at the severity of the offense. As someone not wearing a seatbelt may be an oversight. I don't think it is possible that there is no malice involved. It's just careless, an oversight. But this one, careless driving, reckless driving. It is driving without due regard. And I think this is a major concern, and I would recommend that you increase this fixed penalty from $1,000 to $5,000, and you look at maybe even increasing the amount of demerit points. I consider it a major offense on the road.
Thank you, Honourable Senator. I was hamstrung by the existence of Section 72 of the Act. So Section 72 of the Act currently prescribes a penalty, the pecuniary sum of $1,000 and disqualification. The demerit points at 6 was intended to indicate the severity, but I couldn't take the fixed penalty beyond the parent section, which was at 1,000. So we had kept that in harmony with that. But the look that we're doing in respect of the overall offenses, etc., is the second haul that we're doing on this law. So we're looking at some of these things very, very carefully because there's a second exercise to come, particularly because we're also looking at it in the RFID introduction and how that's going to impact upon a number of other things. So because we've got that work product to come, we're hoping to catch that revision in that same line.
But you do agree that careless driving
Yes, sir.
is a pernicious act on the road?
Yes, sir.
Right.
29.
Sorry, Madam Chair, forgive me. Senator Mahabir sparked a good observation. In fact, the 1,000 referred to in the fixed penalty point has to come out because it's going to be treated with as on the offense side in Section 72. So, in fact, that should be deleted.
What is being deleted?
The
Attorney General?
1,000 in reference to careless driving at item 28.
And you leave the demerit point?
Yes, ma'am, because it's after conviction. Thank you, Senator.
Item 29.
We propose no amendments, ma'am.
Item 30.
Item 30. Again, Honorable Attorney General, here is a motorcyclist. You did change the fact that someone who is riding a motorbike without a helmet is now going to suffer a more severe consequence. But here is someone riding a motorbike. Okay, he's fully helmeted, but no hands on the handlebar. And you are only going to levy $750 to that man. I'm not concerned about him. I'm concerned about when he dies, what will happen to his mother, sister, brother, and cousins. I think this fine should be seriously raised, Honorable Attorney General, and the demerit points likewise. So I don't know if you can change it now.
Senator Mahabir, if I may, sorry
Yes.
to jump in. I disclose that I have a license permit to drive motorbikes and that I ride them quite frequently, or used to in my younger years in particular. And and Senator Samuel says that he does as well. So he's disclosing as well. But the point is that you do sometimes have to ride with no hands just while you're changing off or something is going on, because the coordination between bike and man is so careful between clutch, brake, left foot, left hand, right hand, front brake, right brake, and throttle, and body weight. Sometimes it takes care of a position where you literally are compelled to take your hands off the wheel for something to save yourself. Your helmet is falling off, something is going on. So it would make a difficulty for riders to comply with that strictly in that fashion, which is why it stays, which is why we propose that it stay that way.
Honorable Attorney General, the way the law is reading is that someone can go on the highway pell-mell and he is riding without holding on. That's what the law says.
He'll get a dangerous driving charge, a
Okay,
careless
dangerous
driving
driving.
charge, a reckless driving charge.
Right.
But AG, that's why many times in riding, you have to defend yourself by touching vehicles alongside you. And 28 also puts yourself, it's a tricky situation because at times you have to defend yourself. Sometimes vehicles get very close to you on the white line.
It does say at least with one hand. Huh?
Yeah.
So you're compelled, even though you're going to crash and fall on a car, to defend
You
yourself.
have to defend yourself, and sometimes you have to hold on to defend yourself.
Items 30 to 34. No, we did 30 already, right? 30.
That was ambitious, Madam Chair.
No, we reached 29, we reached 30. Didn't we just deal with item 29? Yes, ma'am. So we're now on to items 30 to 34. So item 31. Item 32. Item 33. Item 34.
34, ma'am.
Yes.
We propose a reduction. We propose an increase from $300 to $450 to be consistent with item 36, which will appear just a little bit later.
Senator Samuel.
Could the AG explain to me what is meant by the faced or defective identification plate? If the number plate has all its numbers and the colors it's supposed to be, it might have been a little faded, not by choice, but those things are like, what do you mean by that? Can you stipulate it?
Madam Chair, as I've confessed openly to honourable members, we are proposing to import as nearly whole as possible the schedule to Chapter 4852, and this was the exact language referred to in that schedule, some of which, quite frankly, doesn't make sense, but we have asked for the data so that we can clean up by way of order issued by the minister, subject to negative resolution of the Parliament. So it is too subjective in its reflection, and we're looking to see exactly what that really means and what the rationale in terms of enforcement has been and ought to be. So respectfully, I hadn't proposed yet to tinker with this until we had finished the exercise which we hope to bring forward in September of this year.
Item 35. Attorney General, please, because I think there's an amendment.
Yes, ma'am.
35.
We are proposing that we delete this item because it appears to be a duplication with 21(1)B. In terms of item 1, it's a duplication with item 1, which was caught by section 21(1)B. So we're proposing to delete this.
Senator Samuel, yes. Item 36.
Madam Chair, we're proposing to adjust the demerit point down to 3 from 4 to be consistent with item 34, which dealt with the defective or defaced plates.
Ma'am?
On 36, Madam Chair.
No, Senator
37.
Samuel.
Oh, sorry.
Yes.
We're in 37?
We're on
36.
36.
36, I thought we deleted that.
No, we
No, that
deleted
we deleted
35.
Oh, 35, okay.
So item 36, Senator Mahabir.
I have an issue with the word "or." I was under the impression, Honourable Attorney General, that we need to have identification plates both at the front and at the back. So no identification plate fixed to the front or the back of the vehicle. So if I have one fixed to the front, but none fixed to the back, then I'm okay.
No, it's an offence.
Okay, but according to what is here, it says no identification plate fixed to the front or the back of the vehicle. Should or not be an?
Which is correct, because you may be driving, you have one at the back, and your offence is that you fail to have one at the front.
Right.
Or you may be driving, you have one at the front, and you have none at the back, and your offence is that it's not at the back. So the language captures the intent.
Ma'am,
Senator Samuel.
and 36, I had an experience, and I just want to share this, a small experience that I have with the same number plate situation, and it will bring the point home. One of my number plates seemed to have gotten loose and dropped off, and somebody stopped me. I took it up and I rested on my dashboard because I had no screws. Police officer stopped me and says, well, it's supposed to be in the front of the vehicle. I said, well, it's in the front of the vehicle. He says, no, the law says in the front of the vehicle. So he pointed to the front of the vehicle. I said, but this is the front of the vehicle. And we argued for a long time what the front was.
Okay.
You see,
Thank you for that, Senator Samuel. The front is the front. Let's just move on, please. I really don't I think it is clear. So let's just move on, please, to item 37.
we don't propose any amendments.
Item 38.
Well, sorry, Madam Chair. We had proposed to just tidy up the language in 37. So instead of no identification lights on vehicle at night, we've put it to no identification lights for the illumination of identification marks on the vehicle at night.
So that's the number plate lights you're talking about?
Yes, sir. It's coming out of your submission that it didn't make sense.
Yes.
That we sought to renovate that language.
And it's only $300 you're imposing?
Yes, sir.
I think that's a serious charge because for the amount of crimes you referred to before.
Well, because of Senator Samuel's point that you'd have to be at the back of your car to notice it, and you may not have noticed it because you're driving, that we've kept it that way.
Item 38,
Madam Chair, we propose to adjust the fixed penalty sum from 500 to 1,200. It's proposed to be increased, and that's to be consistent with the seriousness of violation and safety issues.
item 39,
We propose that that stay as it is.
item 40,
No amendments proposed.
Okay, clarification,
Yes, sir.
AG. Do you have in mind all vehicles or trucks with defective brakes, transport vehicles, maxi taxis, or is it every single vehicle in the land?
Every single vehicle in the land.
item 41,
Madam Chair, we propose that this be deleted as it's a subjective provision with no real way of testing or enforcement within the domain of inspection examination.
item 42,
We propose...
no changes.
Deleting the demerit one? Madam Chair, we propose to delete the demerit point for this. Senators had observed that paint on a Senator Crease put it as opposed to decal on and other points was of issue.
item 43,
Madam Chair, we propose to reduce the demerit point from 3 to 2 to be consistent with the other items.
I don't know what defective fittings are. I don't know if it's the side mirrors or the headlamps, or what are these fittings?
All of the above, body panels, positions, anything which could fall off and cause an injury. And because it would be too difficult to describe, because each vehicle may be different, it was defective fittings.
Should it be, should it be described as loose and defective fittings? Defective is different to loose.
I think that trying to capture language that gets all of it may take us into problems.
But AG, a fitting is an appendage. It cannot be the fender. That's part of the structure of the automobile. So I think it is. I mean, a fitting is what has been fitted on, and we do need to inform the public as to whether it's side mirrors.
Well, technically, Senator, you could fit anything on as a
Right.
fitting. When you trick out your car, when you assemble your car, when you add on other positions, anything is a fitting once fitted.
But it has to be fittings which are essential for the functioning of the car and for the safety of the passengers and the driver.
Why?
Because there are many optional fittings where people do things to their car to make it look pretty. You can't charge someone
You see,
for
Senator,
an optional fitting.
The problem is the optional fitting whilst you're moving at 80 kilometers per hour could be a lethal object.
So it's a fitting that can pose a danger. Not
Well,
just any fitting, but
it's
a fitting that poses a danger.
It's any fitting, Senator. Because it may not pose a danger while you're stationary, but go at 80 kilometers per hour, fly off and hit a child playing cricket on the side of the road and say goodbye.
Okay, AG, I'm getting some difficulties because suppose I have a little stuffed dog on top of my Austin, and I need to drive, and it's soft, there's a few ounces of sponge, and it flies off. Is that a defective fitting?
I don't think that it would qualify as a fitting.
Senator Mark,
Madam Chair, I'm wondering if the Attorney General would agree that we ought to have some degree of certainty as it relates to definitions. Now, who is going to interpret, Madam Chair? Who is going to determine what are defective fittings? Is it going to be the police officer? And depending on the mood of the police officer. So this is all subjective.
So, Madam Chair, if I could put it this way, yes, it's subjective. It is more so, it's subsidiary legislation. It's Regulation 28(1) that we're importing into the Act by way of schedule. So it's subsidiary legislation, which is reflected by the penalty of $450 and also a demerit point of 2. It is subjective, it's hard to define. It's not so much the marginal note, which is vehicle with defective fittings, that one looks to. It's the body of Regulation 28.1, which we've set out for honorable senators. So I don't think that we can advance too far beyond the subjectivity argument. It's quite true.
So even though that is in the existing regulations, we are just transporting it into these matters that are before us, and we still do not have a clear appreciation.
Well, we do. A fitting, the motor vehicle or trailer and all the fittings thereof shall be in such a condition as not to cause or be likely to cause danger to any person on the motor vehicle or trailer or on any public road. That's very clear.
Point, it has to cause danger, and I think if we emphasize that this fitting can cause danger, it has to be proved.
That's what the
then
regulation
of course
says.
I think it makes it a little bit clearer.
You see, we were looking at the marginal note, which you don't use for interpretation purposes or application of the law.
So clause item 44,
No amendments proposed.
item 45.
None proposed.
Yes, Senator Ramkissoon, item 45.
Thank you, Madam Chair. In light of this regulation, I would like to bring to the attention of the Senate on the 13th of November 2010 Newsday article, Magistrate Rule on Illegal Lights.
Senator Ramkissoon, this is not the time for this at this stage, okay? That was for the debate, and we are now in committee. So, with respect to the item, is there a question that you want to ask?
Well, the point is that this piece of regulation should be either removed or amended. And, well, the explanation would have been based on the ruling of the magistrate court in 2010.
Attorney General.
I'm sorry, ma'am. I confess that I was just distracted for a moment because my other team for the next bill, I'm now relieving of obligations, bearing in mind where we are. So would you mind repeating, please?
No, it was based on the ruling from the magistrate Rambachan in 2010 in relation to illegal lights, that these vehicles are being certified with these
Yes.
decorative lights, and it was basically thrown out. So to have this regulation, if you're certified, then they shouldn't really have this unauthorized lights in front of your vehicle.
So Regulation 28K says there shall not be affixed to the front of a motor vehicle any lighted lamp other than the headlights and side lights, except with the approval in writing of the licensing authority, nor to the rear of a motor vehicle or trailer in any lighted lamp other than the red light prescribed by these regulations, except as permitted by paragraph M3 of this regulation. That respectfully fits squarely within the construction of the Honorable Magistrate Rambachan, because any other light is caught by the except with the approval in writing of the authority. The minute you have your licensing certificate and you pass out with those fog lights and everything approved, you have the permission in writing.
Right, and that was what the case was. Why are you being
So
charged or
sorry to interrupt,
demerited?
so it isn't so much what the regulation said, it was how it was being applied.
Right.
And the judge corrected that. So now it's no longer applied that way. But if you went and you affixed something other than in the manner that it was licensed for, you have to go and get written consent. And that's what this clause is driving at, this regulation.
Be 750 and the 3 demerit points. Okay.
No, once they're brought in and they are licensed as that, that's your permission in writing. That's what the magistrate would have clarified.
Once you get your sticker, your licensing sticker.
Item 46. Item 47.
Item 47, Madam Chairman.
We propose an amendment.
Yep, okay.
Which is to decrease the demerit points from 3 down to 2, to be consistent with the other items relating to the construction of the vehicle.
Okay. But, Honorable Attorney General, my concern is not so much with the demerit points, but with respect to what is stated here, vehicle without 2 headlamps. I'm wondering whether you were not thinking about vehicle without 2 functioning headlamps, because you will have 2 headlamps and none of them are functioning.
Well-
So, and they are visible and so on, but the issue is you want both of them functioning. I certainly would not just want headlamps for decorative purposes. I want them for functional
So
purposes.
it's caught in the regulation, if you read it. Every motor vehicle shall be equipped with a minimum of 2 lamps at the front of the vehicle, 1 on each side, to the satisfaction of the licensing authority. Here's the operative bit. When a motor vehicle is in motion on a road at night, the lamps at the front of the vehicle shall be lighted, and the rays from the lamp shall be of a type approved by the licensing authority. So they must work. Yeah.
49.
49, Honorable AG, I don't know if you are making an amendments to that, but 49 refers to a vehicle without tail lights. I understand the fixed penalty, but because it is in the rear of the vehicle, I think in fairness, it is possible that the driver may not be aware that his tail lights are not working, and that if it is drawn to the attention of a police officer who has stopped him, then he gets the fine, but really I would reconsider whether the demerit point should be instituted, especially in a case where the driver may not be aware that his vehicle has this particular defect. So I can live with the fine, but he may not be aware that his tail lights are malfunctioning because he can't see it.
Honorable Senator, it's a good point. It associates with what Senator Samuel had raised with your non-functioning identification lamps. The first point I'd like you to observe is that we've gone with 1,003, which is the rubric we've used whenever we've used 1,000. So we've kept some consistency there. The second point, however, is that this can cause literally death. I recall very vividly once driving down the highway back to San Fernando late at night. The street lamps were not working on the highway, and I saw one tail light in front of me. And I was driving. I thought it was a motorbike. It turned out to be a car with one lamp, and there was an accident right there. I saw 7 cars roll over a man that night and crush him. So the merit point is commensurate with the fact that a taillight is a very important aspect of a point. The discretion of the police officer to charge you may be different. I didn't know, etc. It's up to him, and often they exercise that. But I'm cautious about disturbing the 1,003 chain together with the importance of it.
What I'm not aware of is the discretion of the police officer. In reading this, I thought it was mandatory that you are driving without a functioning taillight, $1,000 and 3 points. Whether, in fact, you were negligent or not, is it that the police officer who is laying the charge has some discretion once you explain to him that I really couldn't see in the back and I didn't know? Does he have that discretion in the law?
In practice, I'll say that I'm aware that sometimes that is done. As Attorney General, I'll tell you the law must be complied with.
Be compliant, but I want it to be equitable as well, especially when the driver you see, I'm looking at a case where a driver has no demerit points. He has been driving for a number of years without any kind of issue. This is one case where his lights have blown. He was not aware. He is not delinquent. And I'm looking at the ordinary law-abiding citizen who was not aware that the law has been broken and whether, in fact, I want everyone to follow the law, but I also want to be fair as well to that individual.
What about
Before you answer, Senator Samuel, you wanted to say something on this particular item? Yes?
While we were debating, Ma'am, I mentioned the idea of notices, and that if those notices are not attended to within a space of time, which is 24 hours, then those notices should shift into a ticket. I mean, automatically, if they are not dealt with within 24 hours. These are technical things. Anything digitalized, any kind of instrument can blow at any point in time. We're dealing with things that have a lifespan. Every bulb has a lifespan. And if you can check it now and 5 minutes after it's blown, I am suggesting that the merit point system, but that will only apply if the person does not deal with it within 24 hours.
The difficulty, Madam Chair, with the proposition, as laudable as it is that it requires a whole lot of manpower to now chase up the position. This regulation is based in a fixed penalty and a demerit. It's as close to on the spot as possible. It's not a conviction, it's not a charge, not a criminal offense. But if we were to take the notice point, there has to be a mechanism in gear to now chase up the notification, the compliance, etc. And respectfully, the balance in this particular regulation is the fact that having one taillight can cause a significant, or having no taillights can cause a significant casualty, or what's the word I'm looking for? Can cause a catastrophe on the roads. So the problem is that we do need to take care of the point where somebody's driving and they know it's not working and they just don't care. And they take their $1,000 and no demerit points and they're habitual. So the balancing act comes into effect.
But, ma'am, we are living in a state where there's abuse from law enforcement. And I'm saying that openly. And just like how every period of time you have what we call the financial gathering of the police service, where they go out there and issue tickets anyhow. The same abuse happens again without discretion. They can decide we're going out this month and we go in and give people tickets for any little thing on the vehicles. And it has happened, and we have a history of it in Trinidad and Tobago. I am very concerned with such a situation.
Senator, isn't the converse also true? Aren't we living in a time right now where people flout the law openly and there's no respect for law? I recall vividly the suggestions by the last government, which I found laudable, the broken window theory. Every little small matter needs to be dealt with. So there's a balancing act to be achieved here, and respectfully, I can't see how we could remove a demerit point because this may be willfully flouted as well.
Senator Amin?
Thank you for recognizing me, Madam Chairman. I want to make a suggestion, but first I want to ask a question to the Minister responsible for the licensing authority with regards to this point as to whether the Ministry of Works or the Minister or the Cabinet has given consideration to implementing a system that could accommodate, like in many other jurisdictions, could accommodate that information sharing, so that if a person, as in the case that Senator Samuel is suggesting, if that person is seen with a taillight, a broken taillight, and he's given a notice, the second time he is stopped for the offense, he cannot pretend as though he didn't know, which happens regularly.
So I think just a second, I think your question is understood. Who is answering it? Is it the
I'd just like to remind, all of these matters have the proportionate balance of a notice to contest. If you think you've been done out, if the policeman has abused your process, you don't accept the position, it's a notice to contest. So you're not without remedy to that policeman who has wielded some form of heaviness on you. There is still the notice to contest route.
But that doesn't answer my question.
Well, Madam Chair, that's a long-haul policy and notification which we have indicated we're working on. And as the Works and Transport Ministry drives the reforms in the licensing authority, hopefully we can see that birthed.
Sometimes it's okay to just say you don't know, you know.
Item 50.
It doesn't know.
Senator Amin.
What is that?
Senator Amin. Senator Amin, please. Item 50. Item 51.
Madam Chair, we propose, just to be sure, that we remove the demerit points, as there are no points for items 39 or 42, and this is to bring it in harmony. So removing the demerit point.
Item 52.
Yes, Madam Chair, Honorable Attorney General, we really do need to know what an unreasonable distance is. Is it 10 feet, 20 feet? Because I'll tell you why. We know the distance of parking within a fire hydrant is some 3 meters. So there is a specified distance. What is reasonable and what is unreasonable? We are if we can't determine what is unreasonable, I would say strike it out.
Madam Chair, that's a matter for the courts ultimately to decide, and the officer on duty in issuing the fixed penalty to try and prescribe that in law would be difficult because each road or occasion is different in all the circumstances.
You see, I am wondering what is the mischief that we are trying to solve. If we reverse for an unreasonable distance, let us say half a mile, why are we doing it? Because a car is meant to go forward, to reverse only occasionally. Why are we doing it, and why is it in the law? What is the mischief here for permitting people reversing? Is it that it is a normal occurrence and Trinidadians are chronic violators of this rule and they like to reverse on the road? So we need to put it in this law?
Before the Attorney General is going to respond, Senator Richards.
Thank you, Madam Chair. Honorable Attorney General, while I agree with it being in, I cannot fathom that there is not some sort of standardized approach to this by the Trinidad and Tobago Police Service. Because if Officer A can tell me you reversed for an unreasonable distance in the same road as Officer B tomorrow, then there is a conflict there. I don't think it's fair to the public where that is concerned, and in many, if not most of the other elements of the police regulations, there is specificity. I don't think this should be left as unreasonable. I think it's very easy for the police to be able to tell you, is it 200 feet? Is it 100 feet?
You see, to answer that, let's assume that a tree falls into a road. Cars are backed, they're blocked on both sides, you can't do a three-point turn, and you have to reverse for 400 feet. If we prescribe the 200 feet now, we end up in difficulty. It does involve an element of subjectivity, balance with objectivity for the policeman on duty. But to prescribe it strictly will cause difficulty in the operationalization of the law. Bear in mind that we still have the ability of the notice to contest provision if you think you've been hard done in the circumstances.
With that said, so in how many occasions you've referenced an exigent circumstance?
Yes.
Which doesn't really comfort me in terms of the everyday application of the law with respect.
You see, the dilemma in this, Senator Richards, is that it is not, with the greatest of respect, something which one can encapsulate into a more prescriptive definition, because it depends upon the circumstances of each and every case.
Madam Chair, can I come in again? You see, Honorable Attorney General, we did discuss at length careless driving, dangerous driving, and I'm wondering if you removed this very nebulous clause about unreasonable distance, whether the offense of someone reversing in a manner that will cause harm to the motoring public cannot come under the offense of careless driving, and it is dealt there. You see, I think it is excessive, maybe OTOs, to have this one here when we already have careless driving on the...
Madam Chair, I don't think that I could repeat myself much more.
Madam Chair? Item 53, I know that years ago, Port of Spain and San Fernando were the urbanized areas where reversing around the corner at a junction would have been dangerous. And part of the purpose for the law is to protect the motorists. It is dangerous to reverse around any corner where the major road is very busy. And even though the term the city of Port of Spain or San Fernando would have been in the parent legislation, I am asking if we could change this to make it to cover more areas within Trinidad and Tobago where the danger could exist to protect our citizens. So should we put, there are more boroughs now. There are other ways to measure urbanized areas.
So, Madam Chair, the rule which is to be observed relative to the point raised by the Honourable Senator is captured in the last paragraph of it. In the city of Port of Spain or the city of San Fernando or the boroughs of Arima, Chaguanas, and Point Fortin.
I make this point, Madam Chairman, through you, having, as formerly as Chairman of Tunapuna Piako Corporation, being part of a lobby group to have the Tunapuna Town Centre designated as a borough, for instance, that we have not yet reached that stage. But there are other areas as well where you have so much traffic and such busy roads that are not in the definition at present. And so they would not be covered, but the motorist is very much in danger.
Attorney, Minister, Leader of Government Business, we do have to do the procedural move. So I will suspend the committee at this stage, and the Senate will resume. Leader of Government Business.
Thank you, Madam President. Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand.
Honorable Senators, the question is that this Senate do continue to sit until the completion of the business at hand. Those in favor say aye. Aye. Those against say no. The ayes have it. This Senate will continue to sit until the completion of the business at hand. And we will now suspend for 10 minutes, and we will come back in 10 minutes' time.
This is the Parliament Channel and Parliament Radio 105.5 FM.
As much as goods and services, the British Empire facilitated cross-border flows of information and ideas, which ironically helped undermine the empire's hold on its colonies. Among the influences that seeped across the Atlantic into Trinidad and Tobago was Pan-Africanism, a movement launched in London by Trinidadian Sylvester Williams, creating a network of solidarity among black intellectuals and activists across the British Empire. In the ideals of socialism and Marxism, the West Indian working class found common ground with the poor and the powerless the world over. In Port of Spain, the Trinidad Working Men's Association became the axis around which working class mobilization occurred in the early 1900s, until Captain Arthur Cipriani returned from World War I to organize and focus its energies.
Cipriani came with an out-and-out, as he used to say, an out-and-out socialist program. Abolition of child labor, 8-hour day, workmen compensation, and some form of home rule. These were the planks.
With the 1929 depression exacerbating socio-economic conditions, workers lost patience with Cipriani's preference for constitutional change and began gravitating towards more militant options. In Port of Spain, they found the Negro Welfare Cultural and Social Association, a grassroots organization led in part by two outstanding working-class women. Elma Francois was a Vincentian who had come to Trinidad as a domestic worker and was quickly drawn to the Working Men's Association until she too lost faith in Cipriani's approach. The other was Christina King, a labor organizer.
In their range of struggles, which included organizing workers on the waterfront, in the ports, in East Port of Spain, supporting Butler in the 1937 riots, in campaigning on the price of condensed milk and other issues. They also campaigned on issues related to the widening of the franchise and for a more democratic constitution.
Arthur Boccareni marveled at the leadership style he saw at the NWCSA.
When I first met these people, what fascinated me is how the relationship between the men and women in that organization. And in the first place, they refer to everybody by their surnames. Francois was Francois. This other one was Ashby. They never refer to them, so you will never know. When they say Comrade Francois, if you, from the outside, you will never know whether it's a man or a woman you're talking about. And it's the first organization in Trinidad that gave women full leadership.
Ultimately, the variety of ideological platforms helped the cause of representative government by stirring constituencies at every level. By the early 1940s, universal adult suffrage was not only inevitable, it was irresistible.
Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament.
Even he acknowledged his reputation as the enfant terrible of Trinidad politics. A man who delighted in tormenting the British governor and was not above using his corpulent body to stand his ground, even if it meant throwing himself on the ground. Gomes is one of the most truly colorful characters ever to have graced the political stage of Trinidad and Tobago. After the labor riots of 1937, his stocks rose in direct relation to the decline of Captain Arthur Cipriani, the once popular working-class leader whose conservative brand of politics was swept away by a rising tide of militancy.
Just say he was the leader of the working men when they had no shoes, but when they got shoes, he failed to make the next step.
In South Trinidad, the working class masses deserted Cipriani for the messianic grassroots leadership of Tubal Uriah Butler, while in the north, the ebullient Albert Gomes, then a member of the city council, proved more in sync with the popular culture than Mayor Cipriani. Albert Gomes made his name challenging the status quo and championing the rights of colonial society's rejects, such as steel bandsmen and shouter Baptists. At every turn, Cipriani was outmaneuvered by Gomes's keen sense of drama. It hit a high note during debate on Gomes's motion against the mayor's ban on public meetings in Woodford Square. More than 70 years later, Woodbrook resident Doreen Ahow vividly remembers the incident.
He lay down on the floor and it took 4 policemen to move him. That was one of the things they talked about with Bertie Gomes. He was so insistent on what he was saying that he lay down on the floor. It took 4 policemen because he was big
On the Franchise Committee, the two squared off on the issue of whether the right to vote should be given to all. In the end, Cipriani voted against universal adult suffrage, while Gomes came out in strong support of the vote for all without income or property conditions. In a minority report, he argued it was precisely the poor who needed the vote. Along with committee members Adrian Cola-Rienzi and Ralph Mentor, Albert Gomes campaigned successfully for everyone to have the right to vote. 1 year before the first election under universal suffrage, Arthur Cipriani passed away, creating a vacancy in the Legislative Council. In the ensuing by-election,
The Honorable, the President.
Honourable Senators, we will now resume the committee stage. Where were we at? Item 53. I think Attorney
53 in the ninth schedule.
You were to respond to Senator Amin.
I was dealing with the issue of the provision of the inclusion of boroughs, etc., and I had pointed out to the last paragraph of Regulation 38, Rule 1, which already provides for that, Madam Chair. It says, in the city of Port of Spain or the city of San Fernando or the boroughs of Arima, Chaguanas and Point Fortin.
Right. I'd asked with regards to other areas that, and I used the Tunapuna as an example, where you have town centers such as Tunapuna, Aruca, and so on, which over the years have become very urbanized, so to speak. And there are some other areas which may not fall under and be named a borough at this time, but certainly the danger to the motorist.
It's built up as much as.
So, Madam Chair, Senator Amin is correct in her observations. We'll have to look at the amendment to the regulation itself, Rule 1, and to look for the density aspects. We probably need to have a conversation with Town and Country Planning and the municipal corporations through the Minister of Local Government. Regrettably, in this particular schedule here, we're not seeking to amend the regulation itself. So perhaps we could take it under advisement and come back with the subsidiary legislation in the second hall, but it's a solid point.
Okay, I just want to add, AG, for your consideration, you indicate you would come back in the near future with new legislation. We do have data, census data with regards to density, but we also have to look at traffic density, not living density. Yeah. So I look forward to that.
Thank you, Honourable Senator. Thank you, Madam Chair.
54.
Madam Chairman, Attorney General, a lot of vehicles, modern vehicles, have a timer that sets the vehicle off after a few minutes. How does this apply? Because there are quite a number of vehicles.
Yeah,
that is a turbo
intercoolers.
timer.
Understood.
And it continues to work and it automatically trips off after a few minutes. How does this apply?
Good question. 38 says, every driver of a motor vehicle shall comply with the following rule. He shall, before quitting the motor vehicle, stop the engine and apply the brakes. I guess one could technically argue that one did stop the engine. The intercooler is not the engine running. It's the cooling aspects of the engine.
There are vehicles that are left running and automatically the intercooler trips everything off.
I think you're right, but I have no response to that because I just simply don't
So here
know.
it is, an officer sees you exit your vehicle, lock it off and you leave, and he charges you and his intercooler with the engine running and it has a timer to it.
I recall, I can think of a number of instances where that has happened. Honourable Senator, I'll have to have a discussion with those that regulate that point because I couldn't advise on it now. Yes, sir.
55. Item 56. Item 56?
Yes.
Yes?
I'm just asking for clarity here. Does this cover on the, well, the highways that we have now where there's a third lane? In terms of overtaking
Yes, sir.
on the left?
Yes.
So you can or you can't, according
It does. So your point is,
If you're
you
on the
are in the middle lane, the guy on the right is not moving, you see a space on the left and you overtake it. It's caught that way. Because you're technically supposed to move onto the right lane and overtake.
Wow, thank you.
Madam Chair, I hardly ever see signs that say keep left except when overtaking again on the highways. Is that a willful thing, or is it something that has become obsolete? Because if you drive the highways of Trinidad and Tobago, there are no signs. Years ago there was no signs that says keep left except when overtaking. Has that gone?
I couldn't speak to the frequency from the north-south run as I do frequently. It is there. So I could only speak to the north-south run, which I traverse almost daily. Well, they certainly are on the Uriah Butler Highway.
57. Item 59. Item 60.
Sorry, before we go to 59, I
No,
just
no,
want...
we're on item 60.
Okay. Well,
Is there something you wanted to raise?
yes.
Senator Mean,
Yes.
what item are you wanting to raise
It
on?
was on 58.
All right, but you realize that we're on item 60?
Yes, I do.
All right.
So I'm asking if you would, I'm asking if you would allow me to go back.
Continue, Senator Mean. We will revisit. I caution members again to please keep up with the program because we've been here a long time.
Yes.
All right? Item 58,
Yes,
Senator
Madam
Mean.
Chair, Madam Chairman, the issue, the overtaking on the right, that sort of feeds into what was mentioned previously, where we now have 3 lanes and 4 lanes on the highway. And while the rule about overtaking on the left came about when you had 2 lanes, now the situation is different. And I am asking that if we cannot put something different here now, that consideration should be given, perhaps using examples from other places, to adjust this, given that we now have highways with more than 2 lanes.
The rule is that you shouldn't improperly overtake, not just that you shouldn't overtake. So you shall not drive so as to overtake other traffic unless you have a clear and unobstructed view of the road ahead. You shall not overtake such other traffic unless you see that the road ahead is clear or sufficient distance to enable you to overtake and get back to your proper side before meeting any traffic coming into the opposite direction. So all that it talks to is that aggressive cut-in approach on the right, and I think the regulation as crafted is worthy.
Not necessarily on the right.
I wondered if, are there any other observations in relation to this?
No improper overtaking should take place, but...
Chair, sorry.
Madam Chair, could we volunteer that demerit point of 6 should be reduced to 3?
Yeah, that was...
Senator Samuel, you're still on item
Yes, ma'am.
58?
Yes, ma'am.
Yes?
Yeah.
Attorney General.
Yes, sir.
You were quoting the Parent Act.
Regulations.
Regulation, sorry. But the Parent Regulation, does it stipulate that overtaking must only be done on the right? Because it was written at the time when we had very narrow spaces. If there is a clear view and a clear path on the left lane, clear path, no obstruction, does this Doesn't it allow for overtaking? Does it stipulate that you can only overtake on the right?
Yes, those are the driver's regulations that we all sit and pass.
Well, then you need to change that because we have
And
3
Madam
lanes
Chair,
and 4 lanes now.
Just to be consistent with clause 58, if we drop down from 6 to 3, it would require harmonization with clause 56.
Yes, that's
where
what-
6 should drop to 3 as
Yes.
well. So with your permission, just to harmonize between
That
58,
56 should be
56,
3 as well.
and in fact 59, that we adjust those, but we're not yet at 59.
But we went back.
Yes, ma'am,
Good thing.
So
apologies.
let us just get item 58, you've made an adjustment.
To 3 demerit points.
Item 59, you've made an adjustment.
Yes, ma'am, to 3. And 56 as well.
56 as well. Okay. All right, it's very important, Attorney General, that we have the information for when we are putting this
Rereading.
clause with
Understood,
all
ma'am.
the amendments. Okay?
Yes, ma'am.
All right.
I see the clerk of the Senate making careful notes. So, item 56, Madam Chair, we're proposing the reduction down from 6 to 3 demerit points. Item 58, a similar reduction from 6 to 3 demerit points. And item 59, a similar reduction from 6 to 3 demerit points.
So now we move on to item 60. Item 61. Item 62. Item 63. Item 64. Item 65. Item 66. Item 67.
Item 67. Madam Chair, item 67, again, I don't know what excess spark means, and it seems to be a pervasive character of some of the words used in this piece of legislation, but also I can't see the justification for 2 demerit points on something that we cannot define.
Sure. Madam Chair, we acknowledge the demerit points and we propose.
I need to hear. Okay, thank you.
Madam Chair, we propose to delete the demerit points at 2. We accept that the Honourable Senator has raised some points in relation to this. We've set out the body of the regulation for ease so that we're not confined to the marginal note, which was the danger in the schedule. And Regulation 38, Rule 13, says that you shall not permit sparks, smoke, or visible vapor of any avoidable nature which would cause annoyance or danger to the public to come from any motor vehicle in his charge or near any public road, and shall take proper precautions to prevent the unnecessary discharge of lubricating oil on any road. So we felt it prudent to put forward the language which helps to clarify that rather misleading marginal note.
Item 68.
68 again. 68, Madam Chairman, again, the excessive projection. Okay.
Excessive projection.
Yes, ma'am. We've bothered to set out the full body of Regulation 38, Rule 15, which again gives a much more descriptive context of what excessive projection is. When read in its totality, I think that senators can be comfortable. Insofar as the fine is at $750, I propose that we reduce this from 3 to 2 demerit points to be consistent with the rubric that we've taken so far, Madam Chair.
Item 69.
From 3 to 2.
Item 68.
68 has a demerit point 6.
In the bill or?
Sorry, no.
In the 9th schedule?
I see. Yes,
Yes,
ma'am. Thank you all for your careful guidance. We
So you're
propose
going-
that the 6, which is in the bill, thanks for the point out, be reduced to 2.
Okay.
Item 69.
Madam Chair, we propose that the amendment move from $750 to $1,000 and instead, and in fact that we maintain it at 3. We should not move it to 4. Yes, ma'am. And it stays at 3.
Item 70.
Chair, I was just going to ask a question.
Just to put it on the record, sorry, on 70. Again, we propose that we take this up to $1,000, from $750 to $1,000, and that we maintain the penalty of 3 demerit points.
Item 71.
71, Madam Chair.
71, Madam.
Item 71, as it reads, means that a broken down vehicle left on the road unattended has no time stipulation. So unattended for how long? An hour, 2 hours, 3 months? I would have preferred, for some clarity, unattended for an extent, and I know the mischief you're trying to solve, but unattended for an extended period, and then plead to the court that, well, okay, I was just unattended for a day to get a record as opposed to 3 months.
So in the table, we've set out Regulation 38, Rule 18 in its full context, that you shall not leave or permit to be left on any public road any motor vehicle which has broken down without taking the requisite step to indicate its presence and positioning by lighting or otherwise, or other persons using the road, and shall take immediate steps to have it removed as near to the left of the road as possible. So when you read the regulation itself, it makes sense. Again, it's dangerous to just rely upon the marginal note, and specifically, we've not proposed any demerit points for this.
Thank you, Madam Chair. In this case, following from Senator Mahabir's point, you explained the points of specificity. There are some circumstances in this level of criminality where you just have to leave the vehicle for your own safety. You know.
But not in the middle of the road. So the regulation prescribes, put it to the left, get it out of danger's way, but don't just leave it in the middle of the road.
I understand that, but in some instances you may not have a choice, and understand the danger that poses. But if my truck breaks down on the beat, I'm in the center lane, I cannot move it. And I also cannot stop to ward off drivers of the impending danger. So it poses a different kind of peculiarity.
So in that circumstance, what's being asked is that you don't abandon it there without taking such precautions as you can. In that circumstance where you've shut down in the middle of the road and you can't move, you would still be in the car.
Actually, no, I'll be running. If it's on the Beetham Highway, I'll be running very fast to try to find a police station. I would not stay in the car at all.
Sure. Madam Chair, it's a very rare...
And excuse me, I may be actually going to get police assistance, which may be half an hour off, and come back and see a charge. You know, I understand the precaution, but it's so vague in terms of the circumstances that I may find myself in.
Unfortunately, I don't know how to treat with the balancing act between needing to prescribe for it, because if left unregulated, people may just leave it there, as opposed to the exceptional circumstance where you get $1,000 potential risk, but you may have a very good excuse for it. Look, it's in the middle of the Beetham and I was being shot at, or it's in a dodgy area and something went wrong, in which case you issue a notice to contest. Because for this policeman to come up and give you the $1,000, you would have to, it's a fixed penalty offense. So there's a time proximity between the police acting to issue the police.
May I offer a suggestion?
Yes, please.
If we could insert, without immediately seeking to have it moved to a safer place.
We're not actually amending the regulation in the schedule. All that we're doing is prescribing the penalty and the demerit point. The regulations are amended in a different way.
I want to then suggest, Madam Chairman, that the fine be similar to that of like where you have the parking within the 9 meters of a corner and so on, which is $500, that the fine be similar. So instead of $1,000, if it could be $5,000. 500, sorry.
Sorry, where's that? Which clause? Which
That the
item?
fine, the fixed penalty
Item?
for item 71.
Yes.
If it could be similar to item 61 and 62. Because most people value their vehicle in that, and they really are not going to leave it there indefinitely. They really are going to try to seek to protect their vehicle.
Parking up alongside, etc. I mean, technically.
Yeah, change to 5.
Sure, that would be acceptable. So, Madam Chair, that we reduce from $1,000 to $500, and that we don't, and we continue to not prescribe any
No demerit.
demerit points.
Madam Chair, item 72. I think the demerit points of 6 is onerous and it is not consistent with the
We agree.
1,000
We
and the
propose
3.
to reduce it to 3.
Very well.
Item 73. Item 74. Item 75. Item 76.
Madam Chair.
Samuel, item 75. No, we're on 75.
Madam Chair, I'm on 75, if you will.
Yes, item 75.
Madam Chair, we propose that we reduce the demerit point from 3 to 2. And similarly, when you come to it for 76, from 3 to 2.
Clarification. Is a reflecting mirror the same as a rear view mirror? What is a reflecting mirror? It is a term, and I'm familiar with many automotive terms, but I'm not familiar with the reflective mirror term.
Quite interesting, because right now some people actually have in their rear view mirror a computer-assisted position. But a reflecting mirror is defined in the regulation 40, as we've put it out, to say that every motor vehicle or trailer other than a motorcycle shall be equipped with the following. A reflecting mirror so constructed and fitted to the motor vehicle as to enable the driver of such motor vehicle to be or become aware of the presence in the rear thereof of any other vehicle, the driver of which is desirous of passing such motor vehicle. So in the expansive definition, they try to capture what it means.
Mirror.
Yes, sir.
Very well.
Yes, side mirror as well.
Item 76.
So we're proposing the reduction of demerit points from 3 to 2 in item 76.
76, 77.
Item 76. Item 77.
Item 77. We really need to remove the demerit points and look at this fine, because really, it's a noisy vehicle, Honorable Attorney General, a vehicle with a lot of noise, the vibrating music coming out. Is it one where the engine itself is making noise, where the music system is making noise? I know there is mischief there, but I do not know what exactly it is.
So, Regulation 43 reads as follows. Any person driving or in charge of a motor vehicle which causes a loud noise to the annoyance or disturbance of any person is guilty of an offense under these regulations. That is a nicely wide version, because you are causing noise. It could be from the muffler, it could be from your music system, even though there's a separate regulation that deals with music, which we have actually amended, which you'll see in a little while. But this is the subject of great annoyance for a lot of people, particularly in residential neighborhoods that now have bars and associated, in Sangre Grande in particular, in Woodbrook, in San Fernando. We have some significant problems with these.
Thank you, AG, for the clarification. I think it was important in my mind to get clear that we are talking about the music emanating from a vehicle and not just the engine noise
could include
of a vehicle.
both.
So it can include both.
Yes, sir.
Very well.
So, AG, what you are saying is based on the discretion of the police officer, whose noise threshold might be very low. That
It's the similar language to an offensive language charge. The police officer can't himself say it's to his annoyance. There has to be a third party.
But they're based upon somebody saying it's noisy. So if one person says it's noisy and the rest says it's
It must
all
be
right.
one person other than the policeman.
That's crazy.
So the famous simplified version called a cuss case. A cuss case can never pass, obscene language case, where the policeman says, he cussed me. He used such language offensively as to cause an annoyance to that person over there, and I charged him. So there must be a third party.
Senator Amin.
Madam Chairman, I want to ask the Attorney General if consideration is being given in the drafts that he promises us in the new term for provision to measure the noise, because such instruments do exist, and then put a value, whether it is a decibel value or what, as to what would constitute a disturbance.
Sure, Madam Chair, that's dealt with by the EMA right now. The EMA has actually provided me with some evidence as to how they monitor that, where they deal with statistics for charges between 2011 and 2016, and they deal with exactly that point based upon decibel levels, etc. So there's that cohort assistance.
Right, so it is there, but I know you indicated that at this time you are not doing changes to the offences in this act. You are dealing with the penalties. And I'm asking if, when consideration is being given to changes in the actual offence, you can draw on the provisions in the EMA authority that exists. But I'm asking for consideration to be given for something more objective to be used to determine what is a disturbance or what is an annoyance.
I'll certainly try to look at it, Madam Chair, because it may involve the use of technology, much like a breathalyzer or the other positions, and then there's training, procurement, other factors.
Yes.
That is why AG,
Senator Samuel.
that's why I had a little difficulty, because the AG's justification is that it is the annoyance of someone else besides the police officer.
Yes, sir.
How does that other person determine the decibel levels or judge the decibel levels of
They
everything?
can't.
Just based upon his own annoyance?
It's entirely subjective.
Wow.
Item 78.
Chair, I understand the need for having 78, but I am not aware of whether we have the mechanism to determine defective tires. Is it that we now have objective devices to measure tread wear? Is it by visual inspection? Is it subjective or is it objective? That's all I need to ask. A defective tire is a dangerous thing, but how are we going to measure it?
It's subjective.
Item 79.
Madam Chair, we propose that item 79 be reduced to 2 demerit points.
Item 80.
Item 80, Madam Chair, I need clarification on, and I want to refer item 80 to item 77. They both refer to the concept of noise. One is the music emanating together with engine noise. Now 80 is playing a musical or noisy instrument without permission. And I don't know if the Attorney General is considering music trucks at carnival time, what he is considering, but really for consistency, if in 77 we have a fine of 300 and 2 demerit points, I can't see the justification for in 80 for having a fine of 1,000 and no demerit points. So, because noise, we are dealing with noise. Is it that you are going to lower the fine and have a demerit point to make it consistent with 77?
Good questions. What does musical instrument mean?
Yeah.
Is a music stereo system a musical instrument, or is it a device? It's in need of renovation, which is why we are taking that second pass. You've raised a very important point. You've traversed, Honorable Senator, our culture, which is carnival, and the fact that we have significant trucks, etc., as part of our culture. It may not be the phenomenon in other jurisdictions, which is why this has been treated with a higher penalty of $1,000, because it does allow you in the text of Regulation 49 to obtain the consent of the licensing authority to actually have that. So music trucks obtain consent, etc. So yes, during elections and other points. So this particular position was intended to treat with our particular culture as it relates to music, because of its frequency and part of culture. They had not proposed to add in the demerit point, but we are looking at the renovation of these regulations and matters in the second pass that we're taking, which we're hoping to finish by September.
For consistency, I would recommend a 2 demerit point as well, since 77 has 2 demerit points for a simple stereo system or engine noise.
Because it's such a part of our culture, music trucks and other points, and these are large things, I'm sort of reluctant to put in a demerit point just like that. Believe it or not, the car systems cause the real trouble for residents at night. The loud noise that comes from engines or positions. I mean, there's a famous bar that the Minister of Works and Transport constantly reminds me of, just in Sangre Grande, where the music that pitches out of this is at such an obscene level that you have to go repeatedly to ask the people to bring it down. So I haven't yet gotten the position on how we should redefine this regulation. And respectfully, I'd ask that we leave it the way it is until we get that data.
Madam Chair, through you, the amendment to the regulations, this has been amended in this particular legislation before us.
Not in the schedule where we're talking about the fines and penalties. So when we come down to the language of the regs, just hold a moment.
Because item 10 says we're repealing the regulation 49 of the Parent Act.
Yeah, I'll refer you to it in just a moment.
Because we are repealing it.
Yeah, but we've dealt with the language differently. So it's in the first schedule to the bill. And if we look to just a moment, huh? Right. So it's at item 10, and we will be looking at regulation 49, and we're putting it now. Any person who plays or operates any instrument, television, video, radio, tape deck, compact displayer, amplifier, equalizer, or speaker, or other electrical or electronic equipment for the purpose of playing music or other electrically or electronically transmitted sounds in a motor vehicle to the annoyance of any resident or person in the street or any person in the place to which the public is admitted or has access without written permission to the licensing authority is liable under these regulations, and the driver of a motor vehicle who permits a person to contravene this regulation shall also be liable under the regulations. So that's at page 57 and page 58.
So, Madam Chair, is there a further amendment to that regulation?
Well, we're coming to that because this comes further down after the schedule. So I was dealing with the fixed penalty and demerit points. And on this one, we're proposing the $1,000 and the no application of demerit points because of the appreciation, as the argument has been put to me, of the cultural aspects of it.
Item 82.
Madam Chair, item 82. Again, I do not understand it because I see a public service vehicle without a spare tire. I know in the definition section we define what an emergency vehicle is. A public service vehicle without a spare tire carries a fine, fixed penalty, $750. I don't know who is paying this fine. Ultimately, is it the government of Trinidad and Tobago that has to pay a fine to itself?
Yes.
Is it the permanent secretary, the administrative officer? Yeah, and how often has this law been enforced?
Yes, the answer is yes.
So it's the government of Trinidad and Tobago is paying a fine to itself.
Yes, sir.
Who is going to, if there is a contest, there can be a contest in the court, couldn't there?
You see, this also ties into conditions of employment, where the driver who has purposes to maintain the positions may have to indemnify the state and have it docked out of his salary. So yes, the answer is the state will pay, but it doesn't preclude the state from taking action against the person who was employed to observe the law in the first place.
Clarification, if this is contested, who will go to the magistrate's court to contest it? Who represents the state here?
The permanent secretary or the chairman or the corporate secretary or the authorized officer or any other person, whether by bylaws or law or otherwise.
Honorable AG.
If I could just also add, the current law defines a public service vehicle to mean, quite interestingly, a motor vehicle used for carrying passengers for hire or reward, whether at separate and distinct fares or in respect of places or not. So the definition in Chapter 4850 is that a public service vehicle is that.
Government vehicle then?
Well, it may not own, it's not only, I mean, you may have public service by definition, but the act as defined, we're treating with servicing the public.
Right. So it includes taxis?
Yes, sir.
Okay.
Maxis.
If it includes taxis and maxis, then why is the fine so low? You see, I thought this was a Ministry of Works vehicle that is caught driving without a tire, public service. No, if it is a taxi that is not equipped with a spare tire and can inconvenience a number of passengers, I'm wondering why not demerit points then, Honorable Attorney General? Why only a fine of $750?
We in Regulation 76, it reads, the driver of a public service vehicle shall comply with the following regulation. He shall carry at least one spare inflated tire fixed to the rim, spare wheel or other device capable of being fitted to a wheel or axle. We did not propose the positions of a fixed penalty because we had not yet finished trawling through the positions and we had left the law exactly as it is. So the importation of all of these regulations, 81 to 100, are the exact law as it provides until we get to the renovation of it.
Item 83.
I don't understand what is the importuning of a passenger. What does that mean?
Regulation 78, which this relates to, reads as follows. No owner, driver, or conductor of a public service vehicle plying for hire or any other person shall speak, make any noise or sound, any instrument in order to attract the attention of the public or a possible passenger, or by troublesome and frequent demands, or by persistent following, hold out the vehicle for hire to the public in such a manner as to constitute a nuisance, or any act in such a way as to cause annoyance or inconvenience to any person, translated into common language, tout or touting.
Madam Chair, this is ridiculous. And I say it's ridiculous because on any taxi stand, you have people going at different distances. Some going up the hill, going down the hill, depending on the village you're working in. And the people who are going up the hill are in the same line, and they will have to be saying up the hill because there are people going up the hill and they alone going up the hill. There are people who are going normal and they will go normal. But in order to inform people, I mean, this is ridiculous. I mean, I don't think the drafters of this, it lives in reality in Trinidad and Tobago to realize that, you know, there are differences in every village, differences in every place of people who travel and commute on the roads of Trinidad and Tobago. This is ridiculous.
There's a qualification in the regulation, which we've set out for you, where it says, in such a manner as to cause a nuisance. Senator Samuel, it's the existing law. It's something that we are looking at in an holistic approach, and I respectfully can't go any much further than that right now.
Item 84.
Are you really continuing with item 84, Honorable Attorney General?
This, much like the rotten tomatoes provision in the Municipal Corporations Act, causes me concern, which is why the technocratic team is looking at the position.
Give us the assurance that when you return, hopefully it can be removed.
For the umpteenth time? Yes, sir.
Very.
Item 85. Item 86.
Madam Chair, if I can go back to 85. Attorney General, would this apply to public transport? Or are we just discriminated here? Because I know many public transport vehicles.
Well, I recall vividly Senator Crease raising the issue of what he called wrapped. And it is something which I think is in dissonance with contemporary positioning and something which has to be looked at. And I'd like to complete the consultations with the police and with the licensing authority on the matter. For now, it stays, the recommendation is that it stays where it is, which is the $300 penalty.
86, item 86. Item 87.
Madam Chair, we propose, well, 87 was inadvertently included. It should be removed because it was repealed by Legal Notice 34 of 2003.
Madam Chair, may I indulge you by asking you to just revisit 86? Attorney General, let us be real. You know, you have taxi drivers who might be plying their trade, Madam Chair, and as my colleague said, they have to rush off to go here or there to use whatever they have to use. And within a 5-minute period, you know, there's no driver in the seat of the vehicle.
Or standing nearby.
What happens? Can a police officer, you know, issue a ticket because of the absence of the driver during those few moments? How do you interpret this?
Technically, the answer is yes, qualified by the existing practice, which is where they usually look for you. Much like when they come to tow your car, that the officer really ought to make an inquiry as to where you are. We notice right now that they just roll up, jack up, and move.
Even if you're right there.
Even if you're right there. This particular regulation 81.2 provides that you should, where a taxi is at the head of the rank at a public stand, the driver thereof shall, except for good and substantial cause, the proof whereof shall lie on him, remain standing by or seated in the taxi. So there is still the notice to contest, there are still the positions, and we've imported the law from the regulations as they are.
Item 88. Item 89. Item 90.
Madam Chair, we propose to reduce the penalty demerit point from 6 to 3.
Item 91.
Madam Chair, I think item 91 may be another one of those throwbacks where we are failing to preserve a taxi badge. I can't imagine a taxi driver deliberately destroying or defacing his badge and then telling the magistrate, well, magistrate, I failed to preserve the taxi badge against loss or destruction. He simply would say it is lost, it has been destroyed. So I think it is one of those things that we can remove and not injure the public interest in any way.
We'll be looking at it, Madam Chair.
Item 92.
Madam Chair, we propose to reduce 4 demerit points to 2.
Senator Mahavir? Your mic is on.
Oh, sorry.
Item 93. Item 94. Item
94, Madam Chair. Item 94, again, I see a possibility for consistency. It is an offense, a major offense. You're driving uninsured, but the fixed penalty is 1,000 and the demerit points is 6. For consistency, 1,000 and 3 seem to go together.
Agreed.
Item 95. Item 96.
Madam Chair,
Item 95, Madam Chair,
to
again.
harmonize 5 down
Harmonize.
to 3.
Yeah.
To 3.
AG.
Yes, please.
Yeah.
And similarly for 96 and 97 when we get there. And 98 and 100.
Senator Amin, 95.
Yeah, 95. Yes, 95. The Parent Act that speaks about driving or parking within the Queen's Park Savannah was formulated years ago. Even in local government, there are rules with regards to parking on recreation grounds and so on, which of course probably wouldn't come in this. The bylaws of the regional corporations makes it an offense for a vehicle to drive on a recreation ground that the corporation is in charge of. However, I'm sure at some point Minister of Local Government would give consideration to including that. But I want to suggest that at this time, we should not be having demerit points for driving within the Queen's Park Savannah, particularly where during festivals we have regulated driving being permitted. And there are very often well-organized people to direct and that kind of thing. So I want to suggest that, given that this was an offense years ago, based on how we were developed, that we should perhaps take off the demerit points completely, and later on integrate the offenses in the bylaws of the regional corporations with regards to driving on recreation grounds, so that it would be in line with the offenses within the schedule.
Sure. Madam Chair, the Ministry of Agriculture has supervision of the Savannah, not the Port of Spain City Corporation. The laws are anchored in antiquity. There is a need for harmonization. We do have, in the provision of special events, etc., the permission to have the regulations suspended and special conditions introduced, which is what usually happens at carnival time, etc. Would you permit me a moment on the demerit point position? We agree with the suggestion to remove the demerit points at this item, and should it please you, Madam Chair, we propose to delete it.
Item 96.
Madam Chair, we propose to reduce 1,004 to 1,003, please. 3 demerit points.
Item 97.
Similarly, to reduce 4 demerit points down to 3.
Item 98.
Madam Chair, we propose to reduce 4 demerit points to 3.
Item 98.
Sorry, forgive me. We had proposed from 6 to 4, but now I'm proposing 6 to 3. Apologies. Thank you for the correction.
98 and 100 go together. And I think they are serious offenses. They can cause accidents. They can cause distractions. And I'm simply wondering whether, given the range of offenses you have which carry a $1,000 fine, which are not as serious in relation to injury, whether you are will not consider raising the fine to $2,000 and 6 demerit points, both for the use of handheld devices, and in 100, it may very well be like a smartphone. And I think you want to discourage people from using that and have the fines.
Senator, very laudable suggestion. However, we're not yet finished with traversing the data, and we propose to come back to that. So I actually agree with you, but I'm not in the position yet armed with the data. In fact, what I had proposed in 100 is to reduce the 4 to 3 just to make it commensurate for now, and then come back on the second hole.
Item 99.
Attorney General?
Yes, sir.
Madam Chair, I'm wondering, in 99, you have someone who is teaching someone to drive, and that person is using a handheld device. He's charged $1,000, but he has the demerit points don't exist for him. But in 98, you have 3 demerit points, and in 100, the AG is proposing 6 or 3. Yeah, so I'm asking the AG, do you not see a disparity there? Why the discrimination against somebody who is
the rationale is that learner drivers are so vulnerable to difficulties that the person who's teaching needs to be equally attentive, needs to be as equally attentive as the learner. And in those circumstances, we're seeking to put that positive obligation.
So there's 3 demerit points left?
Yes, sir. 4. Senator Mark, I think you've caught, however, very usefully the fact that there are no demerit points for 99 and that it should be introduced there to 3.
So what are you proposing?
So, Madam Chair, we're proposing that 98 be $1,000 and 3 demerit points.
Madam Chair.
Proposing that, yes, that 99 be $1,000 and 3 demerit points, and that 100 be $1,000 and 3 demerit points.
While I understand the point to balance it, the person who's committing the offense is not driving.
Correct.
That's right, but he's responsible. So,
Senator Shriki Soon, I've had recently the privilege of watching my nephews, nieces, and children learn to drive as they've now come of age. The Senator Ramdeen, I think it's best to just stay quiet for the rest of the session, you know. Right? Yes, you are. You are. You.
The range have to do it, you.
Yeah. No, I do, and I like locking up people too, and I'd be careful.
Right, okay,
I like it. Right, we've been going well. Just keep quiet.
Madam Chairman, the Attorney General is threatening the member on the side.
Yeah. AG.
I don't know how you reached there.
I want to know what he means by that threat.
Yeah.
I want to know when you all want to include me in the conversation. Senator, Attorney General, please, we have reached this far, and I will ask everyone to comport yourselves accordingly. Attorney General, please do not direct any crosstalk to anybody. Speak directly to me. Okay? Thank you. Senator, I think, Attorney General, you were dealing with Senator Shriki Soon's questions.
Yes, Senator Shriki Soon, is it on the position of the driver, the person who's teaching the learner? Right. And the position inside of there, I was saying that the person who is conducting the training is required to be as attentive, if not more, when they don't have the physical control of the car. I recall vividly, as a learner myself, having those clutch and brake pedals go across to the driver's side of the car. But I didn't see that in the modern version of the learner conductors who were teaching. And in those circumstances, the distraction can be a significant problem. So the proposal was to have that person who is teaching the learner be as attentive as the learner himself or herself is.
Right, and my point is just that you would have penalized him using the fixed penalty, but you're now assigning demerit points in a capacity where he's not driving. So but he's actually performing a function.
But remember that the learner driver is under the care and supervision of the driver who's teaching.
Right.
And that is the position.
I'm understanding the difficulty, AG, but I'm just thinking, and my point here, and I rest it after this, is just that I didn't think that he's worthy of demerit points, given that he's not occupying a vehicle and driving it. That's my only consideration.
Duly noted. Thank you.
We have some consequential renumbering to do on account of the several items that were deleted. Right? So we can just make a general statement.
Sure. Madam Chair, I'd just like to note for the record that as a result of the deletion of certain items, as we've indicated, that there will be some consequential renumbering, and I'm just putting it on the record so that it can be attended to by the CPC's department. Thank you.
Concluded item clause 47. So I will now have the honorable senators. It's 47. The question is that clause 47 be amended as circulated, further amended as follows. ninth schedule, item 2, by deleting 4 demerit points and change to 3, and substituting for 3. Item 4, by deleting 3 demerit points. Item 7, by amending the third column to replace the sum 450 with 1,000 and to increase the demerit points from 2 to 4. Item 12, by deleting the demerit 12 in the demerit points column and replacing it with 9. Item 14, by deleting 14 demerit points in the fourth column and replacing it with 6.
Madam Chair, just at 14, was there also a deletion of 3,000 and reduction to 1,000?
It's 1,000 that's in the bill.
Thank you, ma'am. Appreciate it.
Item 15, by replacing 6 demerit points with the figure 3. Item 16, by increasing the fixed penalty from $300 and increasing it to $1,000, and decreasing the demerit points from 4 to 3. Item 17, from replacing 6 demerit points in the fourth column to 3. Item 21, by increasing the fixed penalty from $750 to $1,000. Item 22 is deleted. Item 23, by increasing the fixed penalty from $750 to $1,000 and to providing for 3 demerit points in the fourth column. Item 28. This is item 20.
Yes, it is. Yes.
In item 28, by deleting $1,000 from the fixed penalty, and that's it. Item 34, by increasing the fixed penalty from $300 to $450. Item 35, by deleting the item. Item 36, by decreasing the demerit points from 4 to 3. Item 37, in the first column, by setting out no identification lights for the illumination of identification marks on vehicle at night. That will be the description of the traffic violation or offense. Then, yes, that is the amendment to item 37. Item 38, by increasing the fixed penalty from $500 to $1,200. Item 41, by deleting the item. Item 42, by removing the demerit points. So there'll be no demerit points for item 42. Item 43, by decreasing the demerit points from 3 to 2. Item 44, no, sorry, item 47, by decreasing the demerit points from 3 to 2. Item 51, from removing the demerit points. There'll be no demerit points for item 51.
56.
Item 56, by reducing the demerit points from 6 to 3. Item 58, by reducing the demerit points from 6 to 3. Item 59, by reducing the demerit points from 6 to 3. Item 67, by reducing the demerit points from 2 to 0. Actually, let me put it another way. Item 67, by deleting the demerit points. Item 68, by reducing the demerit points from 6 to 2. Item 69, by increasing the fixed penalty to 1,000. Item 70, by increasing the fixed...
And deleting, oh, sorry.
It's already three. It's already three.
Item 70, by increasing the fixed penalty to 1,000. Item 71, by decreasing the fixed penalty to $500. Item 72, by decreasing the demerit points from 6 to 3. Item 75, by decreasing the demerit points from 3 to 2. Item 76, from decreasing the demerit points from 3 to 2. Item 79, from decreasing the demerit points from 3 to 2.
87.
Item 87, to be deleted. Item 90, by decreasing the demerit points from 6 to 3. Item 92, by decreasing the demerit points from 4 to 2. Item 94, by decreasing the demerit points from 6 to 3. Item 95, by decreasing... by deleting 4. So there'll be no demerit points for 95. Item 96, by decreasing the demerit points from 4 to 3. Is that correct?
Yes. Yes.
Item 97, by decreasing the demerit points from 4 to 3. Item 98, by decreasing the demerit points from 4 to 3. Item 99, from 6 to 3.
Item 99.
Hold on, I'm just trying something here. Item 99, by providing for 3 demerit points. And 100, item 100, by reducing the demerit points from 6 to 3.
And the consequential renumbering of the schedule.
Honorable Senators, due to those amendments, there will be consequential renumbering of the items. So, Honorable Senators, those in favor say aye.
Aye.
No, I said it. Okay. I did put the question already that as circulated and as not as yes. So those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it. Question 47 as amended now stands part of the bill.
Madam Chair, may I
Clause 47 as amended.
indulge you by asking you to revert to the 8th schedule?
No, before we... 8th schedule, Senator Ma?
I can answer the question on the 8th schedule if you wanted. Huh?
You remember we had please.
Yes, but I thought that we could just finish off.
Okay.
Because there are a few. Okay. And then we will go back to the ones that...
No problem.
Sure. And yeah.
So clause 47 as amended now stands part of the bill. Clause 40.
Clause 48.
Honorable Senators, the question is that clause 48 now stands part of the bill. Honorable Senators, the question is that clause 48 now stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 48 now stands part of the bill.
Clause 49.
Honorable Senators, the question is that clause 49 stand part of the bill. Honorable Senators, the question is that clause 49 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 49 now stands part of the bill. Senator Mark, Attorney General, we now have to go back to the clauses that were deferred.
Sure. Senator Mark had just asked about the 8th schedule. I've confirmed that the company does exist, is still in operation. It's under the Ministry of Health. They are looking at its future, but it still for now in law does exist. With a board and directors, yeah.
Well, Madam Chair, Attorney General, a search was conducted at the company's registry online, and the National Hospital Management Company is not listed. So I don't know, for instance, if it how it operates, because if it's a company, it ought to be listed in the registry.
We inquired of the Ministry of Health at the same time, and we have been informed and advised by the Ministry of Health that it is in existence with a functioning board of directors. In the circumstances of the information you've given, I'll make sure to go and check as to the parity between the company registry's records and the Ministry of Health's records.
So there's a board of directors?
Yeah, as I'm informed by the Minister of Health and the Ministry of Health, yes, sir.
Senator Shriki.
Point of clarity, I'm unsure if municipal police can issue fixed penalty notices, and if they need
Senator Shriki, we can't hear you.
Sorry, Madam Chair. I'm unsure if the municipal police can issue fixed penalty notices, and if they need to be included here in Schedule 8.
I'm sorry, I missed that. I didn't hear it properly.
I'm unsure if the municipal police can issue fixed penalty notices, and if they need to be included in this 8th.
Yes, they can.
Do they need to be included in the 8th schedule?
Do they need to be included in the 8th schedule?
No, they will be.
They are defined as constables and therefore have the authority to issue.
So where do we go now? So, Honourable Senators, we are now going to revert to clause 35. What did we stand on?
Separated. So we do Senator Mark's amendment first.
Okay, yeah. I have given them.
Madam Chair, on clause 35,
Yes.
we had stopped at 88Q as a result of recommendations by Senator Choate in particular and the considerations of the Senate. We have taken the liberty to circulate a proposed text for the 88Q as it stands, which is now in circulation before honourable members. For the record, Madam Chair, the proposed amendment to 88Q, which is the amendment of the existing Section 18 of Chapter 4850,
General, you can take the members through the amendment.
I'm sorry, I thought it came from the team. Yes, ma'am. At 88Q, the new wording suggests division of the complication that we had in the existing law, which we're reintroducing into the part that we propose to remove. And instead, we propose the amendment as follows. Where a person who, under this part, is disqualified from holding or has been refused from obtaining a driving permit, A, applies for a permit, or B, obtains a permit while so disqualified, is liable to a fine of $2,000 and imprisonment for 6 months. So we had proposed to keep the fine and imprisonment within the context of the existing clause, Section 88. Subclause 2, where a person who has been refused a driving permit applies for or obtains a driving permit without disclosing such refusal, he is liable to a fine of $2,000 and imprisonment for 6 months. So we've sought to separate the two. Madam Chair.
Madam Chairman,
Okay. I defer to Senator Choate and then I will come in.
unfortunately, with all due respect, Honorable Attorney General, this doesn't address the issues which we had raised. Apart from being, how should I put it, ungrammatical in subsection 1, it seems as though they are talking about the same thing in both subsections. So, in subsection 1, you are saying where a person who under this part is disqualified from holding or has been refused from obtaining a driving permit, has been refused a driving permit, applies for a permit, or obtains a permit while so disqualified, is liable to a fine. Okay, so if we correct the grammatical error, where does that leave us?
I confess that I'm seeing this for the first time in its written form, so
yes.
I join you in some of the observations there.
Certainly, and the second thing is, where is the mens rea reflected here? I think that was one of the big issues with respect to the three parts of 88Q. Now, the second part of 88Q had dealt with where you are disqualified from driving a particular class of vehicle. And I don't see that reflected in the proposed amendment.
Sure.
And then we go on to 88Q2. It seems as though what is being said here is that it's an offense to apply for a permit or obtain a permit after you've been disqualified. That's fine. And then it's also an offense for you to do so without disclosing such refusal.
And we've also left out, as I look at it, the drafters have left out where you drive the motor vehicle.
Yes, and I thought the whole intention was that where the failure to disclose was with the intention to deceive.
So let's do some surgery on it. I share the same points. I agree with you.
Yeah, I.
Senator Choate, Honorable Madam Chair, through you. The CPC's team has suggested that Section 42(1) and 74 of the existing Act can take care of the person driving without a permit. So 42(1) treats with where you don't have a permit and you're driving, and it's treated with there, and so too 74.
94.
Sorry, 94, forgive me. What's open there, however, is whether you wanted to create some form of aggravation or exacerbation for the fact that you're driving when you know you shouldn't have. So that's a question mark. In the draft that circulated, if we without addressing the mens rea just yet, look at it this way. Where a person who, under this part, is disqualified from holding or has been refused a driving permit, A, applies for a permit, or B, obtains a permit while so disqualified, he shall be liable to a fine of $2,000 and imprisonment for 6 months. So I've stuck a pin on mens rea there. Is there a view on whether the mens rea should be qualified in this?
So, because the application is in the original contributions that I think Senator Mahabe and I had both made, we had suggested that the word applies doesn't necessarily connote intention to deceive, which is really what you want to get at.
How about knowingly or knowingly and willfully?
Well, that doesn't work quite as well. You have to
With
show that the
application.
person is doing it, as your side note shows, the person is doing it to deceive the authority.
Chair, could I come in here at this point because I have a suggestion?
Sure.
And my concern was that the process of application in itself was not a major offense that warranted the penalty. But this is what I would suggest for you, Honorable Attorney, to capture what I had in mind. Where a person who under this part is disqualified from holding or has been refused from obtaining a driving permit applies for a permit under another name, which is a fraudulent application, or obtains a permit under another name, which is a fraudulent receipt, while so disqualified. You see, it's a question of the fraudulent action of engaging in certain behaviors which are meant to deceive, as opposed to simply applying and hoping that the records in the office, transport office, are not up to date. This is a person who has deliberately changed his name, and this individual is intent on defrauding the authority, misrepresenting himself. And if he applies for a permit under another name or obtains a permit under another name, it captures exactly the ill effect, the crime that this individual is committing, which will then warrant the fine that we have and the imprisonment. So there has to be something a bit stronger than simple application. It has to be some criminal act of fraud, in my mind.
Honorable, I beg your pardon, Madam Chairman, may I? Honorable Attorney General, unfortunately, I have to disagree with Senator Mahabir because I think the intention is to prevent fraudulent or false applications for driver's permits from the licensing authority. I think generally speaking, that is what we are trying to prevent. So we should not provide for the commission of the offense in only one way, because people can probably think up a million ways
prescribe it down
by which they can try to get permits after being disqualified. So this is why I was suggesting that we insert the with intent to deceive, which would capture all kinds of deceptions. And with respect to subsection 2, because of the way in which it has been worded, it's superfluous. So what I'm thinking is perhaps without disclosing such refusal could be included in the first part of the section. So you have two conditions, essentially, with intent to deceive and without disclosing.
Sure. Thank you. I too agree.
And I agree with Senator Cho that we need to broaden the range of offences, which would include more than simply a change of name.
Would we mind putting our collective minds to some surgery on the wording here?
Madam Chair?
Senator
Well, okay.
Sorry, Senator Cho, just to ask you, Senator Cho, in including potential language of with intent to deceive, would you suggest that that go after the word permit, or that we put it in after disqualified?
Madam Chairman, if I may reply, I would suggest that it goes after permit.
Right, so where a person who, under this part, is disqualified from holding or has been refused a driving permit, comma, with intent to deceive,
And without disclosing such refusal. Unless, do we really need that anymore?
No, with intent to deceive. Madam Chair, I would guess with intent to deceive captures everything.
yeah?
Yeah.
So with intent to deceive,
Yeah.
A, applies for a permit, or B, obtains a permit, while so disqualified,
Yeah.
comma, shall be liable where a person who under this part is X does A or B, while so disqualified, he shall be liable to a fine of $2,000 and imprisonment for 6 months. Okay? And then 2, where a person who has been refused a driving permit applies for or obtains a driving permit without disclosing such refusal, he is liable to a
Madam
fine.
Chairman, if I may, Honorable
Yes,
AG,
please.
we are saying that 2 is no longer necessary.
I agree with Senator Choate. I think 2 is superfluous.
Yep. Yes. Or has been refused. Yes. Agreed. Because refusal is in 1. Okay? So, Madam Chair, through you, 88Q can potentially read as follows: where a person who, under this part, is disqualified from holding or has been refused a driving permit, comma, with intent to deceive, A, applies for a permit, or B, obtains a permit while so disqualified, he is liable to a fine of $2,000 and imprisonment for 6 months.
Accurately captured, AG, what the intention.
Entirely thanks to both of you, Senator Choate and Senator Mahavir.
Just for the record, Madam Chairman, I don't think this conveys really that the licensing authority has an obligation to ensure that that fraudulent applications are not processed. It puts the burden completely on the applicant, who I think should be held responsible as well. But I feel that the licensing authority should be the one, as the regulator and the one to issue the permit, who should have some responsibility to ensure that fraudulent applications are not processed and not accepted.
Madam Chairman, if I may? Sure. Yes. The thing is, that can be captured by existing law, aiding and abetting, joint enterprise, conspiracies, and so on. So it's not necessary for, in my respectful view, for it to be included here. Looking at the section again, I was thinking that perhaps if we had to insert anything at all, it would have to be with intent to deceive the licensing authority. Because that's the body that controls the issuance of the permits.
Could it be caught by the fact that they make the application to that body?
Well, I agree. I was just wondering whether you know, in order to leave no room for ambiguity, whether that should be inserted. But
I think it won't hurt. But I think it is excessive because there is only one place you can apply for a permit and obtain a permit. That's the licensing authority. So unless we have a number of licensing authorities, we don't need to mention it. It is understood. I don't know, in law you probably have some implicit word or something.
No, sir. Your point of view is actually correct, but I'm respectfully managing Honourable Senator's submission. And I thank you both for the improved version and for the original draft, Senator Choate. Thank you.
Senators, we are now in a position to finalize Clause 35. There are several amendments. Some of the amendments had been circulated by the Attorney General. There was an amendment proposed by Senator Choate. There's an amendment proposed by Senator Mark, and then there's this last amendment that we just dealt with. So I'm going to deal with Senator Mark's amendment first. Okay? Senator Mark, correct? So the question is that Clause 35 be amended as follows in subclause D2 by deleting the word negative and substituting the word affirmative. Those in favor say aye. Aye. Those against say no. No. The noes have it. This amendment is not passed. Then we have the amendments. Yeah. Well, let's deal with Honourable Senators, we'll now deal with the amendments as circulated by the Attorney General as shown on the list of amendments. Clause 83 3B. Members? Those in favor say aye.
I give you the document.
I apologize, Madam Chair.
Senators, the question is that Clause 35 be amended as circulated and further amended as follows. In Clause 87A, by deleting subclause 1 and subclause 2 and substituting with the following new paragraphs. 87A1, where any person is charged with manslaughter or offense committed by use of a motor vehicle as a weapon or with contravening the provisions of Section 70 or Section 71, it shall be lawful for the court to order the suspension of the driving permit of the person so charged pending the determination of the charge. 2. Any such permit so suspended under subsection 1 shall be surrendered to the clerk of the court before which the person so charged is to appear. And then we're going to, there's a proposal to add a subclause 3, which would read, where the court makes an order for suspension of a person's driving permit, this order shall be received on every occasion that the matter is listed.
Sorry, Madam Chair, shall be reviewed. Not did I hear you say receive? Reviewed.
Yes. This order shall be reviewed on every occasion that the matter is listed. And then we go to 88Q. And then, Honorable Senators, the amendment to 88Q. Okay. Then, Honorable Senators, in subclause 88D1A, by inserting the word exceeding after the word not and before the word 75. Right?
Yes.
And then we go to this one. And then now, Senators, the further amendment to 88Q to read as follows.
And you have to delete and then.
So 88Q will be deleted and substituted. The following will be substituted for the 88Q. 88Q1, where a person who under this act is disqualified where a person who under this part is disqualified from holding or has been refused a driving permit with intent to deceive, A, applies for a permit, or B, obtains a permit while so disqualified, he is liable to a fine of $2,000 and imprisonment for 6 months.
Just adding the word, as they say, comma, after permit and before with. Yes, ma'am.
Madam Chair, I just want to confirm that the first part of 88Q ends with a full stop after the word road. It starts off because 88Q was divided, and
it ends with the word 6 months.
Okay. Okay. If a person who could I just for my own clarity, if a person who under the provisions of this part.
This has been deleted.
It has been deleted.
Yes, and you're now going to substitute with the words that I've just read. A new 88, a different 88Q, 1.
Yes. No one. 88Q.
88Q, where a person who under this act is who under this part is disqualified from holding or has been refused a driving permit with intent to deceive, A, applies for a permit, or B, obtains a permit while so disqualified, he is liable to a fine of $2,000 and imprisonment for 6 months.
But, Honorable, through you, Madam Chair, Honorable Attorney General, 88Q was supposed to be divided into 2 parts. One, to address this issue of a person who is applying, but the first part, Honorable Attorney General, to address the more serious charge of a person who is disqualified but who is operating a vehicle with no license in his possession. So we cannot only have 88Q1. We
But
do
Senator
need...
Mahabir, that was extensively discussed.
It's caught under 42(1).
Okay, all right.
Yes.
Right, and 94. And Madam Chair?
Yeah?
Could I just ask for one consideration on the words as read out?
Sure.
There's a concern some of my Minister of Agriculture has expressed, and I'd like the reflection on this. One may be disqualified from holding a permit, one may be disqualified from obtaining a permit, or one may be refused a permit. And therefore the question is whether we should modify what is proposed by adding in the category of or obtaining, so that the final language would read, if senators accept, where a person who, under this part, is disqualified from holding or obtaining or has been refused, so I put a comma, or obtaining, comma, or has been refused a driving permit. A, applies for a permit, or B, obtains a permit. While so disqualified, he is liable to a fine of $2,000 and imprisonment for 6 months, full stop.
Deceive.
Sorry, with intent to deceive comes after permit, sorry, comma, with intent to deceive. A, applies for, B obtains, while so disqualified, he is liable. So I'm proposing to add in or obtaining.
Madam Chairman, that seems eminently reasonable.
Thank you.
So may I just let me just reread it one more time?
Yes, please.
Hopefully. 88Q, where a person who under this part is disqualified from holding
Or obtaining.
or has been refused a driving permit with intent to deceive, A, applies for a permit, or B, obtains a permit while so disqualified, he is liable to a fine of $2,000 and imprisonment for 6 months.
Exactly. Yes, ma'am. Madam Chair, just for the record, we'd need to insert the marginal note for that particular section. Thank you.
So, Honorable Senators, the question is that clause 35 be amended as was recently set out. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 35 as amended now stands part of the bill. Clause 12 revisited. What did we do?
Madam Chair, with respect to clause 12, we had a bit of confusion, which we've clarified, where the suggestion as a result of an earlier amendment was that we should change the word or to be consistent with and. But when you reread it in the cool of reflection, really what we're suggesting is the complete deletion of the words or imprisonment for 6 months and also the words or imprisonment for 1 year, so that we're fully decriminalizing, so there'll no longer be an and or situation. No, not at all. We're deleting it clean. There's no and, there's no or imprisonment. It all comes out.
So you're deleting sub A? Or
Yes. So clause 12, as expressed in the bill, is proposed to stand without any amendment.
So it's not amended. All right.
I thought we had clarified that.
Question is that clause 12 stand part of the bill. Honorable Senators, the question is that clause 12 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 12 now stands part of the bill. Yeah.
Schedule.
Honorable Senators, the question is that the schedule stands part of the bill. Honorable Senators, the question is that the schedule now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. The schedule now stands part of the bill. Please look after 49, clause 49, schedule 1. That is the one that we just said stands part of the bill.
The other schedules are part of the clause.
The other schedules were part of clauses. Okay? Honorable Senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye. Aye. Those against say no. No. The bill as amended will now be reported to the Senate. Attorney General.
Feels so good to stand. Madam President, I wish to report that a bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act, Chapter 4850, to introduce a system of traffic violations for certain breaches of the Act, to provide for the implementation of a red light camera system, a demerit point system, and the reform of the fixed penalty system and related legal proceedings and other related matters, was considered in committee and was approved with amendment. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act, Chapter 4850, to introduce a system of traffic violations for certain breaches of the Act, to provide for the implementation of a red light camera system, a demerit point system, and the reform of the fixed penalty system and related legal proceedings and other related matters. Those in favor say aye. Aye. Those against say no. No. The ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act, Chapter 4850, to introduce a system of traffic violations for certain breaches of the Act, to provide for the implementation of a red light camera system, a demerit point system, and the reform of the fixed penalty system and related legal proceedings and other related matters, be forthwith read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act, Chapter 4850, to introduce a system of traffic violations for certain breaches of the Act, to provide for the implementation of a red light camera system, a demerit point system, and the reform of the fixed penalty system and related legal proceedings and other related matters, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. No. The ayes have it.
A bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act, Chapter 4850, to introduce a system of traffic violations for certain breaches of the Act, to provide for the implementation of a red light camera system, a demerit point system, and the reform of the fixed penalty system and related legal proceedings and other related matters.
Acting Leader of Government Business.
Madam President, I beg to move that the Senate do now adjourn to Thursday, 8th June at 1:30 p.m. when we will resume the debate on an act to amend the Offences Against a Persons Act, and taking it through all of its stages, and time permitting to begin the bill, an act to establish a system of plea discussions and plea agreements and for matters incidental thereto.
Madam, I think this is the second time the acting leader made mention of the Offences Against the People Act. I think the bill is the miscellaneous provision trial by judge alone act. I think Bill 2017, I think that is a bill that is properly before the House, which amends the act that she mentioned, and the Criminal Procedure Act. Those are the two. So is not that act before us? Is it trial by judge alone?
To amend the offences against the person, yeah?
It is that?
Criminal Procedure Act.
Well, I have a bill that mentioned trial by judge alone, so I don't know which is the correct bill. Madam President, the bill that I have before me is the Miscellaneous Provisions Trial by Judge Alone Bill 2017. This bill amends the Offences Against a Person Act, Chapter 1108, and the Criminal Procedure Act 1202. That is the act. That is the bill.
Senator Mark, may I guide you to the order paper? And the order paper has, under Bill's second reading, a bill entitled An Act to Amend the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters.
That's wrong.
Senator Mark, I know you said you're confused, so we leave that alone. Okay? Mark is on your June, man.
This is the correct bill.
Senator Mark?
Okay, ma'am. No, I agree that next Thursday.
Honorable Senators, the question is that the Senate do now adjourn to Thursday, the 8th of June, 2017 at 1:30 p.m. Those in favor say aye. Aye. Those against say no. This Senate now stands adjourned to Thursday, the 8th of June, 2017 at 1:30 p.m.